Part heard appeal in the matter of the Financial Conduct Authority and BlueCrest Capital Management UK LLP.
Yes, Mr. Burgess.
Good morning, my lords, my lady. Just to begin by recapping where we are. Before we rose yesterday, Mr. Herberg had just finished making submissions on the construction of the single firm redress power and how we say that the four requirements can be derived from that power. I'm going to pick up from where Mr. Herberg left off by addressing certain of the points that arise on our respondent's notice. Firstly, our submission that the authority's construction of the single firm redress power is not compliant with A1P1. Secondly, why we say that whichever construction is correct and taking the authority's case at its highest, the use of the redress power in this case amounts to a substantive breach of A1P1 and thus strikeout is appropriate for that additional reason. Thirdly, I'll address the related question of why the use of the redress power in this case cannot be consistent with the statutory purpose. And finally, and briefly, I'll address the principle of doubtful penalisation. And I should say that hopefully, if I've done my work on the first of those, I can deal with the second, third and fourth relatively quickly. Turning then, if I may, first to construction, it's perhaps helpful to begin with the question of how the interpretive obligation under Section 3 of the Human Rights Act applies in this case. And we say that it can be expressed conveniently in four stages. Firstly, we accept that A1P1 is only relevant to the question of statutory construction if the court concludes that on ordinary principles absent A1P1, the authority's construction of the redress power is the correct one. And just pausing there, the Upper Tribunal, of course, did not accept the authority's construction on ordinary principles. And it was for that reason that the tribunal did not then need to go on to consider A1P1, albeit the tribunal did make some comments on the point, and I'll come back to that. Second stage, if the court does conclude that the authority's construction is correct on ordinary principles, then it is for BlueCrest to show that that interpretation is incompatible with A1P1. Thirdly, if I do persuade you that it's incompatible, then the court must, if it's possible to do so, read Section 55L in a manner which is compatible with A1P1 in order to address the non-compliance on the facts in this case. And fourthly and finally, we say that BlueCrest's construction of the statute offers that compatible construction and thus should be adopted, albeit we accept that, depending on the court's conclusions as to what exactly is required by compliance, other means of attaining a compliant construction would be open to the court. Mr. Herberg has already addressed the first of those four stages, why we say the authority's construction is wrong based on ordinary principles. If we're wrong on that, then we say that the authority's construction is incompatible, given that that construction would permit the imposition of a redress scheme without the need for the authority to demonstrate at a minimum three of the four criteria, so duty, causation, and loss. Specifically, we say that the authority's construction offends A1P1 in that it permits an exercise of the redress power, which is firstly not in the public interest, secondly not sufficiently prescribed by law, and thirdly not proportionate. And I'll address each of those points in turn, if I may. Considering first then public interest. In this case, Parliament has identified and stipulated the relevant public interest which is in play, namely the consumer protection objective. Now, we of course do not say that that objective is incapable of serving the public interest. What we do say, however, is that a construction of the power which permitted the authority to impose redress without the need to just demonstrate at a minimum those three criteria cannot meet that stated public interest of protecting consumers.
Does that mean that anything that the Financial Ombudsman does must be contrary to A1P1, since those aren't requirements for a remedy by the Ombudsman?
Well, my lord, some of these points that I'm going to address, I think, would cut across all of A1P1. I'm addressing this currently under public interest, but we would certainly say that it would not. The difference between the FOS regime is that there's a statutory cap for one thing of I think 350,000 or something around there.
Well, that's not a public interest point. That may be a proportionality point, but the FOS scheme seems to recognise that there is a public interest in being able to provide a form of redress by way of what I would imagine would also be justified as consumer protection in circumstances where there is no loss, duty or causation.
Yes.
And if you're right in your argument that providing redress in circumstances where all those are absent cannot be in the public interest in this context, how can it also be in the public interest for a FOS scheme?
Well, I think taking the FOS example, I think the response would be the proportionality assessment is completely different. I accept that for the purpose of public interest, in that case, where the stated statutory purpose isn't consumer protection as it is here, but I accept that it's a similar jurisdiction. In that case, of course, there is the statutory cap, and that, in my submission, has a substantial impact on the proportionality question, which I'll come on to. But I do accept my lord's point that the FOS criteria does not include these particular criteria that I'm going through now. And as I say, I'm making these submissions under the public interest heading, but I will want to rely on them under the other headings that I'm going to come to in a moment. I think, my lord, you'll have in mind the three particular criteria that we're discussing: the loss, causation, and duty. We say that redress cannot serve the objective of protecting consumers for the purpose of that statutory obligation if consumers have not suffered loss. Ditto causation, even if a customer has suffered loss, it cannot serve the public interest to require an authorised firm which has not caused that loss to pay redress. The consumers in that instance are not being protected from the actions of the authorised firm, and the causing of a loss, we say, in circumstances where that must be remedied, is inherent in the concept of redress.
Is it the case that the consumers we're concerned about in the consumer protection objective in relation to continued permission on conditions are not the consumers who have suffered the loss or not suffered the loss in relation to which the redress is ordered, but future consumers in respect of whom the authorisation to continue doing business as a fit and proper purpose is conditional upon redress for what's happened in the past? The consumer protection objective of a permission condition is aimed, isn't it, in the future at future consumers?
I think that's right. Yes, when one's looking at regulating future performance of a regulated firm, yes, that's correct. I'm going to come on in a moment to address in a bit more detail the question of under the heading of duty, exactly how the authority goes about determining who the customers are or the consumers worthy of protection are. Perhaps I just do that now. Under duty, the crucial point in my submission is that it's entirely within the gift of the authority as regulator to specify by way of rules to which customers a firm has duties. And if I can put it this way, the authority often casts that duty net extremely widely. So taking the financial promotion rules in COBS as an example, those being the provisions which the authority relies on here by way of its amended case. The consumers to whom the duty is owed in that instance includes a client, a potential client, or anyone to whom a financial promotion is or is likely to be communicated, and that's COBS 3.2.1. And for your note, it's Authorities Bundle, Volume 2, Tab 17, page 312. So in that instance, for example, the duty net, if I can put it that way, is cast extremely wide. Now, absent a duty requirement, therefore, the authority is requiring a firm to pay redress to a consumer where the authority exercising its statutory rule-making power in accordance with its consumer protection objective has not seen fit to impose any obligation between the firm and that customer.
Is there a statutory definition of consumer? Because the consumer protection objective is a statutory objective.
Yes.
Don't worry, come back to it.
Yes, if I may, my lord,
And
I'll
I'll
give
just
you a proper answer.
insist, for the purposes of sections 404 to 40B, there is a definition of consumer at section 404E, which is on page 186.
Yes, but that's not quite the purpose. I understand your case to be 55L says you can do this in exercise of your objectives, and your objectives are set out at the beginning of the statute, I think, section 1 something. One would have thought there'd be a definition of consumer for the purpose of those objectives.
I handed a note for Mr. Burgess saying section 1G.
Thank you. Which I
I
don't
don't believe
have.
it's in the bundle. Perhaps we will get that for you, so you can see that.
Thank you.
Having made that point, returning back to the public interest and statutory purpose, in effect, the authority is entitled to determine by way of its power to make rules which consumers are entitled to protection in which circumstances, and does that. And the authority, we say, and appreciating my Lord Popplewell's point, this cuts across a number of my submissions, but we say the authority cannot fairly and consistently with A1P1 go beyond that when imposing redress. And that's why the duty requirement, which is perhaps slightly less obvious than the loss and causation point when one's talking about A1P1, that's how we say the duty requirement plays into A1P1. Now, while as I've mentioned, the Upper Tribunal didn't rule on BlueCrest's A1P1 arguments, the Tribunal did express a view on that public interest question at paragraph 282 of the judgment. If I could just ask you to briefly turn that up, just so you can see what the Tribunal said. It's Core Bundle, tab 15, page 291. My Lord, have you got that passage? So it's paragraph 282 of the judgment. The Upper Tribunal held that any interpreter or commented or made this observation that any interpretation of section 55L read with 404F7, which permitted the imposition of a requirement on BCM UK to pay substantial redress purportedly pursuant to a consumer protection objective without the authority being required to be satisfied that any consumer actually suffered any loss or that the firm caused any loss that was suffered as a result of any wrong which it had committed, may well not be in the public interest. And that wasn't a finding of the tribunal because it didn't need to make that finding, but we say that the Upper Tribunal was correct to express that view. Moving on then to the stipulated by law requirement, we say that a power to order redress that does not require proof of duty, causation or loss is not sufficiently accessible, precise and foreseeable to meet this requirement. The legal principles relevant to the concept of lawfulness in the Convention are not in dispute and have been set out by Lord Sumption in the case my learned friend Mr. Rattan took you to previously, which is the Crown on behalf of P. I would like to, if I may, draw out those principles a bit more. So if I could ask you to turn up that authority again. It's in the authorities bundle, volume 6, tab 54, page 1437. While you're turning that up, this was a case brought by individuals with criminal convictions who contended that the statutory provisions requiring disclosure of those convictions in certain circumstances were contrary to their rights under Article 8 in this case. And the principles applicable to the concept of lawfulness were set out by Lord Sumption beginning at paragraph 14, which is on page 1478. And they go on to paragraph 41. So it's paragraph 14 to paragraph 41. And I'm not going to be able to do justice to everything Lord Sumption said there in the time I have. But I do commend that whole passage to the court. I just want to pick out a few key passages and then draw together some points of principle. So paragraph 16, Lord Sumption sets out the classic definition of the concept of lawfulness in this case. The expression in accordance with the law within the meaning of Article 8.2 requires firstly that the impugned measure should have some basis in domestic law. It also refers to the quality of the law in question, requiring that it should be accessible to the person concerned, who must moreover be able to foresee its consequences for him and compatible with the rule of law. Then moving down to the passage that Mr. Rattan took you to, and I think you read, is paragraph 17. We don't rely on the first three sentences, which concerns whether law is sufficiently published in effect. So to that limited extent, it is clearly accessible. But we do rely on the passage that begins around F of that page. A measure is not in accordance with the law if it purports to authorise an exercise of power unconstrained by law. The measure must not, therefore, confer a discretion so broad that its scope is in practice dependent on the will of those who apply it rather than the law itself, nor should it be couched in terms so vague and so general so as to produce substantially the same effect in practice. The breadth of a measure and the absence of safeguards for the rights of individuals are relevant to its quality as law, where the measure confers discretions in terms or in practice which make its effect insufficiently foreseeable. Thus, a power whose exercise is dependent on the judgment of an official as to when and in what circumstances or against whom to apply it must be sufficiently constrained by some legal rule governing the principles on which the decision is to be made. Paragraph 19, Lord Sumption then cites the Sunday Times case, and one passage from that as follows: a norm cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need with appropriate advice, to foresee, to a degree that is reasonable in the circumstances, the consequences which a given action may entail. Then Lord Sumption quotes from the case of Silver and United Kingdom. And I draw your attention in particular to the second half of the quotation from that judgment. One of the principles underlying the convention is the rule of law, which implies that an interference by the authorities with an individual's rights should be subject to effective control. I stress those words. This is especially so where, as in the present case, the law bestows on this executive wide discretionary powers, the application whereof is a matter of practice, which is susceptible to modification, but not to any parliamentary scrutiny. And Lord Sumption goes on in that paragraph to set out the facts of Silver. And that case concerned the power of a prison governor to stop prisoners' communication at his discretion. The words were, the governor may, at his discretion, stop any letter or communication on the ground that its contents are objectionable or that it is of inordinate length. And as Lord Sumption says there, the relevant restrictions were held not to be in accordance with the law, because in some cases the actual measure of the interference complained of was not foreseeable, and in others the rule under which the stopping was effected could not itself be foreseen. There's then further formulations of similar principles in the following paragraphs. I do just want to pick up one final passage at paragraph 31, which is on page 1486, where Lord Sumption is paraphrasing the authority of CAT, or part of the authority from CAT, and says this: in other words, an excessively broad discretion in the application of a measure infringing the right of privacy is likely to amount to an exercise of power unconstrained by law. It cannot therefore be in accordance with law unless there are sufficient safeguards exercised on known legal principles, and I stress that, against the arbitrary exercise of that discretion so as to make its application reasonably foreseeable. Now, drawing those passages together, I derive the following three non-exclusive requirements of lawfulness. Firstly, that the law must be sufficiently constrained so as to prevent the arbitrary use of the power in circumstances where there can be no parliamentary scrutiny. Secondly, the law must be sufficiently clear to allow persons subject to it to regulate their conduct. And thirdly, the law must sufficiently set out the principles against which the use of the power in any given instance may be assessed and challenged. With those principles in mind, we then turn to the statutory wording on the authorities case, which will be by now very familiar. But just to reiterate, on the authorities case, the constraints to the exercise of the power appear in section 55L2 alone. All other provisions are confirmatory or permissive only. It bears emphasis then that section 55L2 provides only that the power to impose a redress scheme arises if it appears to the FCA that it's desirable to advance the, in this case, consumer protection objective. Now, that is the extent of the constraint on the power that is in the statute on the authorities case.
But not the extent of the restraint on the authorities case. They say, look at JR plus,
Yes.
that can be investigated in the tribunal.
And I will come to that, but in short, the answer to that is that it provides no proper basis no proper safeguards in circumstances where there's no criteria against which the exercise of the power could be judged. So in a sense, the Upper Tribunal, whether it's the RDC or the Upper Tribunal, is in the same position as the authority of having a completely unconstrained power.
Well, it is a little, the plus bit of JR plus may make it slightly different.
Well,
For example, the tribunal can investigate whether the conduct alleged did or didn't occur, whereas on straightforward JR review, that would be something which it was simply for the authority to take a rational view about.
Yes, the plus in effect is
So that the subjectivity, as it were, which is what I understand is at the heart of your arbitrary element, is not quite the same, is it, in the tribunal, if it's not just JR but JR plus?
yes, the plus is in effect the ability to correct errors of fact and law. That's the additional element that makes it a plus. And yes, to that extent, it's possible to do that, but it doesn't say anything about the trigger. The tribunal cannot say to the authority, we don't think it's desirable to do what you're doing. That trigger, the whole power in that sense is unconstrained, and all the tribunal can do is remit it back to the authority with those further directions, which does include errors of law and fact, to make its own decision under the same unconstrained power that we've been discussing. So
presumably, the tribunal could presumably say, well, you say this is for the protection of consumers and in pursuit of that statutory objective, but we're not satisfied that any rational authority could conclude that what you're proposing has anything to do with the protection of consumers. In other words, the rationality is a real question, whether it's something that the authority could properly conclude protected consumers.
To that extent, there is the rationality challenge. That yes, and we do accept that there is that challenge. We say that that's a far too low bar.
Why is that too low a bar? Because it is for the regulator to regulate. So it's for the regulator to decide how best to promote the statutory objectives. That's how regulators work. And if the regulator can rationally decide that doing something promotes a particular objective, and the tribunal is satisfied that it can rationally reach that conclusion, then it's not for the tribunal or anybody else to tell the regulator whether to do it or not. It's for the regulator to make those decisions, because they're the ones given the statutory discretion. What's impermissible in A1P1 terms about doing that, giving a discretion to a public body that has to act in accordance with public law principles as to how best to promote a statutory objective? Because that's very, very common across many areas of law.
I appreciate that, and certainly one answer to that, my lord, is to say, well, this is being relied on by the authority as the means by which this power, which is otherwise constrained, becomes constrained. You could have a certain situation where the statute or guidance sets out all the criteria that a public authority may apply, and then there's a question as to whether that whether the exercise of the power is rational in any one case. But here we have nothing. We have nothing to go on. We just have. I'm being told by the authority that we don't need to have anything by way of constraints on the statute or in the rules, because we have this rationality change. And the point I'm making is simply that isn't proper safeguards unless you have something to judge it against.
Well, why is not the thing to judge it against the statutory objectives, which are necessarily expressed in general terms? Because when you give public bodies wide discretions, you tell them what it is you want to achieve, but you don't tell them how to achieve it. That's for them to decide how to achieve it. And that, I find it difficult to say that there's anything wrong with Parliament giving a public body a quite generally expressed objective and leaving it to the public body to formulate its own policy and principles, which it then publishes and complies with. And if it doesn't comply with its own policy, there are other ways in which you can challenge it. In other words, to leave it to the ordinary public law principles by which public bodies achieve the things they're told to achieve. Well, let me be frank about this. Your submission effectively says you can't give a public body a very broadly expressed objective and leave it to decide for itself how to achieve it, because that's not sufficiently articulated by law. And I'm just challenging whether that's really the position.
I am making that submission because, we're in a regulated sector, but in any sector, if you can have an unconstrained power, and my lord, you referred to guidance and rules, and we accept that guidance and rules can put flesh on the bones of an unconstrained power. There are no guidance and rules in this case, and I'll take you to that to make that good. But that's the position. We are solely left with an unconstrained power and a rationality challenge, and I say that combination is not enough for A1P1. I mean, you can look at it this way and I'll maybe come on to this when we're looking at the first supervisory notice, but what is an individual that receives a first supervisory notice to do when he receives it by way of challenge? If we're saying that the power itself is unconstrained, but don't worry that when it's exercised against you, you're able to challenge it. On what basis can it do so? Against what criteria could it do so? Other than to say, well, I think no rational regulator would have done
got
this.
the facts wrong, or it doesn't promote the objective, or it's not proportionate, and what's wrong with that?
The facts I accept, but I wouldn't be able to challenge the trigger. I wouldn't be able to challenge whether it was desirable or not.
I see. Okay. Yeah.
Other than on the rationality basis, which is a very low bar. So we say, I mean, my learned friend Mr. Rattam referred yesterday to this. The point we were making on this was attacking a straw man because the power is constrained. And with respect, we cannot see, other than the ways we've described, an unconstrained power plus rationality plus, we can't see how the power is constrained in any meaningful way at all. It is just the test of desirability, a pure discretion, and the fact that it is to be exercised with regard to this consumer protection objective in practice, we say adds nothing. By reference to the three principles I derived earlier from Lord Sumption's analysis of the law, firstly, we say an unconstrained power in those terms provides no constraints against the arbitrary use of the power by the authority. So to paraphrase Lord Sumption, we say this power does confer a discretion on the authority that is so broad that its scope is in practice dependent on the will of the authority rather than on the law itself. Secondly, and this is an absolutely key point, we say, it provides no basis for a regulated firm like BlueCrest to know what actions will expose it to the risk of being required by the authority to pay redress, and in this case, redress of some $700 million. To put the point rhetorically, how could a firm like BlueCrest be expected to regulate its conduct so as to avoid unlimited liability arising from a redress scheme when a scheme could be imposed to address customers without the authority needing to show that there's been any breach of duty, that any breach was an obligation owed to the relevant consumers, that any consumer has suffered loss, that any loss has been caused by the firm, or even on the authority's construction, that the activities to which the redress relates were not even regulated activities at all. And that's the effect of section 55N2, which relates back to 55L.
Does it follow from your argument that the power under section 384 to impose restitution is equally bad for breach of A1P1?
It doesn't, my lord, because that is a constrained power. In that instance, you certainly have to show causation and loss, albeit loss or adverse effect.
Or profit, so not loss.
Yes, I accept that. So a further, but there is a further constraint. But these are the basic constraints that we say are necessary for A1P1 compliance, and they do exist in restitution, but they would not exist in this case. And in fact,
Loss doesn't.
It has loss or other.
It's profit or loss or other adverse effect. So loss is one of three, but it can be either of the other two.
They're all different. In my submission, they're all different ways of looking at the problem. There needs to be a harm, whether it's because loss has been caused, or a profit has been gained that shouldn't have been gained, or an adverse effect has been caused. I appreciate they're different concepts, but it revolves around the same point, that you have to point to something that's happened that's gone wrong that needs to be remedied. But in the 55L sense, there is nothing. There is no constraint at all. And I mean, as the court will, I'm sure, have well in mind, this is a sector where it's absolutely crucial that firms are clear as to their obligation and potential liabilities. And also one where Parliament, through FSMA, and the authority exercising its powers, must balance the objective of protecting consumers, which we've spent a lot of time on, against providing sufficient clarity so firms are able to regulate their conduct and operate in a commercially predictable way. We say that a construction of the power which permits this payment of unlimited sums without any practical restraints would really cut across the whole scheme of the statute and all of the statutory rules which have been very carefully calibrated in order to achieve that very important balance. And of course, it falls to us on our side of the court to emphasise the other side of that balance, which is the need for a regulated firm to understand its potential liabilities and to comply with rules and regulations.
Would it meet this objection if we, under the interpretive obligation in section 3, construed section 55L as impliedly requiring that redress schemes should not impose greater liability on firms than profits, loss, or other adverse effect to consumers?
I think my Lord's formulation would potentially address the loss element. We say...
I mean, you've emphasised the potentially unlimited liability. But although, of course, Mr. George says the only constraint is the consumer protection objective, the actual scheme they've put forward is sought to be justified by them, as I understand it, in front of a tribunal, as compensating the external investors for what they say is a loss. Now, I know you say, well, no, that's not right. They haven't lost anything, and anyway, there weren't any breaches and so on and so forth. But that's all a matter for the tribunal, and we were shown yesterday that the tribunal is deciding these points on the assumption that there is a loss. And so, to what extent is this, to use Mr. George's term, a straw man, this spectre of completely unconstrained liability? It's not actually what the FCA say they've done in this case. What they say they've done is imposed a scheme compensating people for actual loss.
Well, my Lord, it's a very vexed question as to whether there is any pleading of loss here, and that's obviously something that's highly contested.
I understand it entirely, but
Yeah.
the FCA's cases, all we're doing is making you compensate people for what they've lost.
Yes. And I think if the statute was to say that your liability was limited to the loss, for example, that would meet the loss element of the complaint.
Would it meet all your A1?
It wouldn't, because certainly you would need also causation, certainly, because it makes no sense to have a consumer that suffered loss and no causal relation at all to the firm that's supposedly being required to redress that loss. So we'd need the causation element. And we'd also, we say, need the duty element, in particular for the reasons I was articulating about how it's in the gift of the authority to determine that duty requirement, and it does so, and it changes its rules often in order to make sure that balance of protection to consumers against liabilities to firms is properly maintained, and it does that. But we say once it's done that exercise, it can't then go on to say, well, that you can have a liability notwithstanding any of that. So that's why we say we need 3. But in terms of my Lord's question as to how exactly one could construe these powers, that's very flexible. That's a matter of form rather than substance. It's perfectly possible to say we put aside our construction of section 404 F7 on this hypothesis and say we would, for example, read in words to 55L or 55N, for example, to say that in circumstances where redress is ordered, these criteria must be met, including.
How about 55N5, which says you can look at past actions and direct remedial action, something like that. How about construing remedial action as being along the lines of redress, restitution in section 384? Would that meet your objections?
I think if it was kept within the same bounds as the restitution power, I think we would accept that would serve our purposes. But I'm reminded that in that circumstance, if the court was to do that, there is the question of why this power would be necessary. But if on this hypothesis, we're saying that the court has already found that it is there, so it is necessary to constrain it at least to within the bounds of the restitution power. I've made the third point. I was addressing going through my three principles that I derived from Lord Sumption's analysis. Firstly, the power would be used arbitrarily, and secondly, that it didn't provide any means for a firm to regulate its conduct. The third was just that this unconstrained power, and I think I've made this point, provides no principles against which the use of the power may be judged. And I will maybe develop that a little bit more in a moment. Now, the authority proposes three answers on this point, and we've referred to them briefly, but I'll take you through them. Firstly, guidance. It said that there is relevant FCA guidance on the use of the power. And as I've said, we accept as a matter of principle that statutory guidance may constitute law for these purposes. And just for your note, Lord Sumption does in fact deal with that expressly at paragraph 43 of P, at page 1491. Here, though, we say there is no such guidance. The guidance that we've been referred to in the authority's skeleton, which for your note is reply skeleton, paragraph 9.2, core bundle 13, tab 133, so it can't be right, core bundle page 208. And the guidance that we're referred to by Mr. Rattan is that set out in the enforcement guide section of the handbook, which is recited at the end of the first supervisory notice. And I think it's important, Mr. Rattan didn't take you to that, but it's important, I think, that I show you that. It's supplemental bundle, volume 2, tab 11, page 425. While you're turning that up, my lords, my lady, I want to note and stress that these are set out here, these regulatory provisions are set out here in part to allow the recipient of a notice to understand the regulatory rules that govern the FCA's power to take the action that is set out within that notice. And to that extent, we say that they are provided in compliance, in part compliance with the duty that you're familiar with in 55Y5 of FSMA to provide reasons for the action. And we say, as an adjunct to the further obligation by way of section 55Y5, to inform the recipient of their right to make representations. So in short, in colloquial terms, this is where a recipient would look to test whether the action is lawful and what lines of challenge may be open by way of the procedural safeguards on which the authority places great emphasis. So if we now just turn to look at each of these regulations, regulatory provisions, we say paragraphs 8 and 9, so 8.1.13 and 8.1.2 does no more than set out the statutory power, adds no flesh to the bones there. Paragraph 10 states that the authority will have regard to the restriction imposed, regard to the principle that a restriction imposed on a firm should be proportionate to the objectives. the authority is seeking to achieve. So it refers to proportionality there. Paragraph 11, it again recites the statutory power and then states 3 types of concerns that may be relevant, and you can read them there. The authority has serious concerns about a firm or about the way its business is being or has been conducted. The authority is concerned that the consequences of a firm not taking the desired steps may be serious. The imposition of a formal statutory requirement reflects the importance the authority attaches to the need for the firm to address its concerns. And then paragraph 12 just says that the authority may at any time of its own initiative impose on the authorised person such requirements as it considers appropriate. Now, the court will form its own view, but we say that that does not add anything by way of meaningful flesh to the bones of the statutory power. The second answer that is against me is the procedural safeguards, and we've dealt with this to some extent. Really, it's the second and third answers. So the second answer is that the authority will act rationally, and the third answer is the right of authorised firms to challenge the use of the power. We say there are 3 main problems with that. Firstly, while procedural safeguards are an important part of the requirement of lawfulness, they are not sufficient on their own, and it's quite clear in my submission how they could not be. They could not, for example, meet the requirement for foreseeability, whereby a firm is able to regulate its conduct so as not to fall foul of a decision to impose a redress scheme in the first place. Secondly, a rationality challenge, even a rationality challenge plus, and I think we've discussed that, in my submission does not provide a sufficiently high level of scrutiny. And I'll come on in a moment to the case of Crown on behalf of Wire, in which Lord Walker said expressly that a rationality challenge by way of a judicial review would not be sufficient to safeguard convention rights in the face of an otherwise unconstrained statutory power. And I accept whenever in each of these submissions that we have dealing with judicial review plus, but I think that's a useful starting point. Thirdly and importantly, and this is a point made by Mr. Herberg, and I think I've already made it, any review cannot provide an effective safeguard, given that the legislation is so vague that the review has effectively nothing to bite on. To use the words in the Silver case, neither the RDC nor the tribunal can exercise any degree of effective control, that was the phrase used, of the power, given what we say is subjective and an entirely imprecise nature of the criteria which constrain it. So that, I think, deals with constrained by law. I deal finally with proportionality. The third way in which the authority's construction of the single firm redress power is incompatible with A1P1 is that it lacks what we say are the minimum thresholds necessary for the proportionate use of that power. And the relevant principles in this regard I draw from the judgment I just referred to, the Crown on behalf of Wire. If I could ask you just briefly to turn that up, that's in BlueCrest's supplemental authorities bundle, which came after the main bundle. Melanie, do you have that? It has 7 tabs. This was a case before the Supreme Court as to whether the operation of the confiscation order scheme under POCA might give rise to an order which violated A1P1. Lord Walker gave the majority judgment and held that the statutory power which provided for the confiscation power on its own did not prevent the imposition of an order which was disproportionate for the purpose of A1P1, and that it was therefore necessary to read in words to achieve this. I'll pick up the judgment at paragraph 10, if I may. That, I won't go through all of this in detail, but that sets out there the issue that was before the court in this case. Then paragraph 11 recites A1P1, over the page at paragraphs 13 to 14, Lord Walker set out the Section 3 interpretive obligation, and I draw your attention in particular to the passage from Lord Bingham in Sheldrake, where Lord Bingham referred to the extent of that obligation. And then the key bits are over the page at paragraph 15 and then 19. So paragraph 15, this is the particular power that was being considered in this case. And you'll see at 16, Lord Walker held that it's plainly possible to read paragraph B as subject to the qualification except insofar such an order would be disproportionate. So those are the words that were read in. So in effect, the confiscation power in its unamended form, if I can put it that way, may have been used in a proportionate way, but it may not. And Lord Walker held that it was necessary, therefore, for the court to read in words to ensure that it could only be used in a proportionate way. And that's what Lord Walker did in this case. And then moving on to paragraph 19, this is the passage in which Lord Walker talked about the rationality, the availability of a rationality challenge. And if I just maybe read this passage to you. The guidance should be issued to prosecutors is perfectly proper. The Crown's power under section 6.3a of Popplewell to ask the court to make a confiscation order is one with far-reaching consequences, and care should be taken to exercise it on sound principles. Section 6 of the HRA imposes on prosecutors the duty not to enact in a manner incompatible with convention rights, so the court has an important preliminary function in ensuring that a disproportionate order is not sought. This is the key passage, but the safeguard of the defendant's convention right under A1P1 not to be the object of a disproportionate order does not and must not depend on prosecutorial discretion, nor on the very limited jurisdiction of the High Court to review the exercise of discretion by way of judicial review. That, we say, is the key passage, and then the remainder of that paragraph, Lord Walker notes that the repository of the control, as it's put there, in that case was the Crown Court. So, drawing Lord Walker's reasoning together then, when faced with a broad statutory power that is capable of being exercised disproportionately, firstly, the protection of A1P1 rights cannot simply be left to the discretion of the party exercising the power, in this case the authority, and must be protected by way of the construction of the power itself in the absence of other rules and guidance that would otherwise do so. And secondly, it's no answer to say that any exercise that is disproportionate may be subject to a rationality challenge. That power must be itself be constrained. And applying that reasoning to our case, we say the single firm redress power as the authority would construe it is so broad that it can be used in a disproportionate way, as in wire. In order to make that power compliant with A1P1, it must be read in a way that ensures it can only be employed in a proportionate way. And we say the requirements of duty, causation and loss are the minimum necessary requirements of a proportionate use of the power. It's not, we say, necessary, as in wire, to read in words. We have a compliant construction of the words that have been offered by BlueCrest. But as I've said, there may be other ways of construing the statute to achieve compliance. My lords, my lady, I'm conscious of time. I think I can deal with the second, third, and fourth points that I had rapidly. So the second was that in the alternative through our construction arguments, even effectively there's been a substantive breach of A1P1 here, because contrary to the authority's case, the authority's statement of case doesn't include an allegation of loss, of causation, or on its unamended case of regulatory, the breach of regulatory duty that was owed to the customers to be redressed. And we'll obviously have to make good all of those propositions. But if we do, then we say that the authority's case that the redress scheme is A1P1 compliant cannot succeed at trial for the reasons I think I've already adequately expressed. It said against me that the question of substantive breach can only be determined at trial and not now, because proportionality is fact sensitive. We don't accept that. Our submission, as it must be, is based on the authority's case at its highest. We say that there is no pleaded case on any of the elements I've referred to, and if we're right about that, we say, in effect, individually and cumulative, they are each prerequisites to a finding of proportionality. And if that's right, then the tribunal should have granted a strikeout on that basis, and we invite this court to do that. Improper purpose, I don't think I need to spend any more time on. It's effectively the same arguments, but applied through the common law. Finally, doubtful penalisation. I think I can skip that, but perhaps I could just refer you to the authority that I was going to take you to, which is the case of ESS and Sully, which appears in the bundle at Authorities Bundle Volume 3, tab 34661. I just give you the note rather than take you to that, and I'll give you the point that I was going to derive from that authority. Really, there's a point of principle and a point of fact. The point of principle is that Lady Justice Arden, in that case at paragraph 78, made it clear that the principle applies to the imposition of a civil liability and not just a penalty, which is much more restrictive, because it's said against me that this is not a penalty, it's a remedial action. That's my principal point. My factual point is that that case concerned with a director was personally liable for an insolvent company's debts, and it was therefore a civil liability that required in effect the payment to third parties who had suffered loss by reason of insolvency. And we say, in effect, there's no conceptually any difference to that type of civil liability and that applies in our case. My lords, my lady, before sitting down, if I could just check that I've covered what I need to cover.
Sorry, can I
Yes.
just ask one question? You accepted that this is JR plus and not just JR, which I think is what Lord Walker was talking about. And you referred, we haven't been taken to it much, but the nature of the jurisdiction, as I understand it, and I'm looking on page 99 of the authority bundle, is yes, the tribunal is looking at questions of fact and law, but when remitting, it looks like it can go further. I'm looking at section 1336A.
Yes.
Issues of fact and law, matters to be or not to be taken into account in making the decision, and procedural or other steps.
Yes.
Can you just enlarge a bit on why that wouldn't be sufficient, for example, in relation to proportionality, which, by the way, on the guidance you took us to was one thing that could be derived.
Yes, yes. We read section 6A, B and C as effectively, well, B is the factors to be taken into account, factors not to be taken into account, criteria that would be applied, irrelevant and not irrelevant factors that would be applied on a judicial review. That's how we read it, and we don't read it any more widely than that. And ditto the procedural steps. So if there's been a procedural irregularity in the way that the decision has been arrived at, then that can be corrected. In short, in my submission, the plus is just 6AA, which is the correction of errors of fact and law that takes it beyond what could be in a High Court judicial review. My lords, my lady, unless there's anything else, I'll hand back to Mr. Heather.
Anything else? No, thank you.
My lord, my lady.
Yes.
Time has a horrible habit in this case of running away with one, and I'm going to seek to make some of my points, not in full, but by reference to the skeleton. I'm picking up the baton at the stage of addressing the proposition that the authority's pleaded case doesn't meet the 4 statutory conditions, dealt with the principles, and now it's the application to the pleaded case. I can take this aspect very briefly before coming on to the second half of the case, onto jurisdiction. If one simply looks at it in terms of the 4 conditions, actionability is easy because it's effectively agreed. If it's common ground that the authority's unamended case didn't plead actionability, we win. We have to accept in our part that the amended case, if permitted, the 3rd and 4th amendments do, at least for the purposes of a strikeout, allege something actionable, so it's met. That's the end of the point. The second criterion is duty. I'm going to address that, if I may, when I address the 2nd and 3rd amendments after I've dealt with jurisdiction, because the two are very interlinked, and once one derives the answer on one gets it on the other, and it's going to be more convenient for the court to hear that all together. That leaves causation and loss, and that raises a very narrow issue of whether the authority has a sufficiently pleaded case on loss caused to investors or to the fund. And at this stage, we're not taking points about distinguishing. Those are duty points about investors or the fund. So we'll just assume amorphously whether there's a sufficient case of loss pleaded. And that case is encapsulated in paragraph 173 of the statement of case, which Mr. George took you to. And I, for my part, before I even go there, must fully accept the disciplines of this being a strikeout point, and therefore, in relation to which one must assume the underlying factual case as pleaded is true. And that's spelt out in paragraph 32 of the tribunal chair's decision, which Mr. George took you to. I don't need to go back to, because all that does is itemise as assumptions of fact in favour of the authority the very words of the pleading in paragraph 173. So one can just look at paragraph 173 and ask, does that plead loss effectively? It's a short point which we address in our skeleton at paragraph 72 to 81, and I don't want to take up much precious time by repeating the submissions in detail. But I do want to put the essence to you, that contrary to the intervention which my Lord Justice Nugee made with my learned junior, it is, we say, there is an argument that this paragraph doesn't actually plead any loss. And I'll put the point very shortly. It's really there for the court to accept or not accept. The pleaded case in paragraph 173, the starting point, is, we say, clearly consistent with the proposition that the investors didn't suffer any loss of return on their investments as a result of any alleged wrongdoing in respect of the management of those investments, even unquantified loss. Indeed, it's consistent with a case that, in fact, as a matter of happenstance, the investors actually did better because the portfolio managers who were transferred and the RMT system, for whatever reason, actually produced a better return. Because there's no case, and it's disclaimed as being impracticable to even allege it in the proposed reply, no case advancing a case that investors suffered loss, that it impacted on, as it's put in the skeleton, consistent long-term appreciation of assets through active leverage trading and investment. That was the objective of the investment management agreement. Instead, what we have is the allegation in paragraph 173, and that is effectively, first, BlueCrest failed to manage the conflict, and that results in a substandard investment management service. The authority contends that the failings by the applicant were such that the level of service received by the investors was therefore below that which could reasonably be expected to be commensurate with the fees paid by the investors. And the short question is whether a label of a substandard service, which was therefore incommensurate with the fees paid for that service, is sufficient to make out a loss case. And we say it is not, because skimped services, and there's a line of skimped service cases which my own friend has taken you to, skimped services are not automatically recompensed. It is only where there is a plea of loss to recipients of service. It wouldn't have to be a plea of loss by way of return, rate of return. It could be some other form or type of loss. But we simply say there is no plea. There's no plea of anything superadded to the allegation that, well, the service was substandard because it was affected by a conflict of interest, and that's we paid for a proper service. They paid for a proper service which was not affected by a conflict of interest. That we say is not sufficient
So what's the nature of the additional loss you say that has to be proved
Well, it
in a
could be
skimped
any-
services case? Not
it-
financial loss? They have to show some financial loss? No?
any form of loss. In most of the skimped services cases, the loss was blindingly obvious, and therefore, as it were, this step is hardly gone through. And we've got examples of people only getting shorter meals than they contracted
What's
for.
the loss in that case?
The loss of enjoyment of the courses they didn't get.
Yes, but it's not a financial loss.
No, it doesn't have to. As I said, it doesn't have to be a financial
Well,
loss.
what would you plead? You plead, I paid £50 for a 5-course meal, and you served me a 3-course meal, which you would normally have charged £30 for. So what do you plead?
In many cases, it may be absolutely obvious. It's loss, maybe
What
loss
you
of
plead
enjoyment.
is, I got a substandard
Yes.
meal. I got a 3-course meal instead of a 5-course meal.
Well,
Why is pleading, I got a substandard service, I got a conflicted service, rather than an unconflicted service, not sufficient?
because an unconflicted service, unlike a meal, is not something which obviously causes any loss, financial or in any other respect.
Why not?
Why are
Why
investors?
Why not? I mean,
Because-
I really don't understand this, Mr. Heather. One of the things I buy when I buy financial services is I buy a proper standard. I want someone who's going to act with integrity. I want someone who's going to act with due care and diligence. I want somebody who is not conflicted. If I get somebody who's acting without integrity or without due care, I've got a complaint. Why don't I have a complaint if I get
It doesn't
someone
follow
who's acting in a conflicted fashion? Because the whole point about conflicts of interest is not that they necessarily cause loss, but that they put the risk on the client. That's what conflicts do.
Lord, we say there has to be a plea. It could be a plea of a risk of loss, but that isn't there. Can I put to your lordship an answer to your lordship's
Well, no, I'm looking at the pleading because this is your point. What's pleaded is substandard service.
Well,
Now,
yes.
you may say, as a matter of fact, having a conflicted investment management service is not substandard, but that's quite a difficult case to meet, and it's certainly not a strikeout.
I certainly wouldn't say that, and absolutely that's not a strikeout.
So-
I'm saying that
so what is
substandard.
deficient
Can I
with
try and
the-
identify that?
Yes, because what we're concentrating on is what's wrong with this plea.
Yes, that's precisely the question. I'm trying to endeavour to show your lordship what's wrong, and perhaps I can do so by 2 examples. One is the example of a service which is substandard because of a lack of compliance with a different rule. Let's say market abuse. Let's say in the course of providing the service, there's no proper market abuse controls, and the investment manager is unlawfully taking account of improper information. Now that could be labelled a substandard service. You are entitled to buy a service that's not afflicted by conflict of interest. It may be that because of the opportunities which the firm has illicitly taken advantage of, the investors have done better than they otherwise would have done. And unless that is reversed, that's cost to the fund. You can imagine a situation where the investors do better as a result of a substandard service. It doesn't follow from there being a substandard service that there has been any loss of any sort, financial or other sort, caused. And that's reflected in the case law. And the example which I was going to take you to is the Louisiana fire case, where the city of New Orleans contracts for a fire service
Is that a
specified.
principle of English law? Because I
Yes,
thought
it's
there's some
yes.
scepticism in the English cases as to whether the Louisiana fire case.
Well, this is the only case I want to take you to on this point, because it is a rabbit hole that one can go down for a long time, and I won't even tell you about jurisdiction. But this is, I'll pick up the paragraph in a minute, but let me give you the point first so that my lord has it. The point is that Louisiana City of New Orleans contracts for a fire service which has various certain number of fire engines. The service is skimped, and it's produced with less than the contracted number of fire engines and firemen. In fact, no fires break out, no loss is caused. And it's held there that is not The mere fact that there was a skimped substandard service does
decision?
not. And that is accepted. But let me take you to the to what this is the discussion of Mr. Justice Stadlen in the Force India case. And it entirely depends on whether I can bring this pleaded case, assuming the facts against me, into that category or not. The Force India case is, my Lord, at tab 37 of the authorities, which is volume 4, page 712. It starts at. It is a huge judgment of some 200 and something pages, but we can without any unfairness dive straight into the bit where the judge is dealing with one of 4 bases on which he considers damages, which are, he calls them performance interest damage claims. It's a skimped performance case because the claimant didn't get the number of laps in practice that he should have got under what he'd bargained for. And if one picks it up at paragraph 434, which is on page 865 of the bundle. At paragraph 434, you've got the Louisiana fire example. And this is, Lord Wolfe is uneasy with that as it not being adequate. Yes. But then you have Mr. Justice Stadlen, top of page 866. On the facts of the case, somewhat unusually, it might be said the value to the city of New Orleans of the skimped performance was not less than the performance that should have been supplied. Doesn't, in my view, follow that the ordinary measure of compensatory damages identified and approved by Lord Nichols and the House of Lords is inadequate in all cases of skimped service? Where the skimped performance consists of the supply of inferior and cheaper goods than those ordered and paid by the shopkeeper to refund and paid for the shopkeeper has to refund the difference in price, yes. Where the defendant provides inferior and cheaper services than those contracted for, the approach prescribed by Lord Nichols presumably involves refunding the difference in price between the inferior and cheaper services supplied and those which the defendant agreed to supply. And then this, and Lord, this next paragraph is the question of whether there is a category into which I can bring the pleaded case. Since in every case, the loss for which the claimant is entitled to be compensated by damages is the difference between the value of what the defendant agreed to supply and what he did supply, one can see that if the inferior or insufficient services actually supplied can be proved to have been no less effective in securing the objective which the superior or larger number of services contracted for were intended to achieve, a court might readily accept that the breach of contract did not result in any diminution of the value of the services contracted for. So my short point is that there has to be a plea which effectively argues, at least, that there is a basis on which the services actually supplied were less effective in securing the objective. Now, the objective was by reference to the rate of return. I accept it could be something other than saying we got a lower rate of return if it was something to do with inconvenience to the fund being kept out of their money, the fund would say. There might be all sorts of other possibilities or some other way in which it was held in a particular case that the fact they'd received a conflicted service had caused some loss. But we say that the plea merely of...
Put Mr. Stadlen's judgment away, but you skipped over the fact that he seems to put... Anyway, this is all speculation, it's not decision. One can see that. He puts the onus of showing that although you supplied an inferior service, actually it was no less effective on the skimped performer, not the skimped performee.
Lord, I accept that, and I read that, and I would accept it at trial. It might be the burden might be on us, but there has to be a pleaded case against us. This point's been identified.
Well, isn't it sufficient to say, I contracted for X, you gave me Y. Y is less good than X, and then that's sufficient to say, on the face of it, I've suffered the loss between what I would have had to pay for the substandard performance and what I actually paid for. And it's for you, if this point is a good point, to say, well, I know we gave you a less good service, but actually the performance wasn't affected. In which case, it is a good plea of loss. It's a defence point, not a
Well,
not a plea, not a.
Well, I won't push it too far, but I would simply say that the less good description which your lordship put to me is precisely the one which, as it were, could fit into either of the buckets, if there are two buckets of the standalone analysis. It could fall within the actually didn't cause any loss. And
It's like
we say,
it's like a restaurant saying, I know I only give you 3 courses and you paid for 5, but actually those 3 courses were just as good as the 5 I would have given you.
impossible. And of course, there's a pleaded that would be impossible.
It doesn't seem to me to be
we say that it's
a point where the claimant, in this case the authority, has failed to plead something which is capable of constituting loss.
Well, the pleading was put. We effectively said no loss, and then there's the proposed rejoinder, which you've seen addressed. So the point's been fairly and squarely raised. We simply say this is a case where one disclaims loss of return. So one is already in a position, a very unusual position. What is it that these investors can possibly have lost if they didn't get a reduced rate of return? What can it have been? One is immediately in a position, unlike 99% of the skimped service cases, where it's very hard to see on that assumption what the investors can have lost, why this is not a New Orleans or Force India case. That is my point. If your lordships and your ladyship take the view that it is sufficiently pleaded and it's all there for argument at trial, so be it, and the argument's taken up then. My pure point is on the pleading basis, we say, having put the point in issue in our reply, there is no comeback saying, but this has to be put in, at least as a reply pleading. We do say that this is not just substandard and not commensurate with the fees because the fees were X and this is worse than that. We have to say something about the nature of the loss case that's going to be made out. After all, this is justifying a redress bill of over 700 million. And on the face of it,
What's the basis for the 700 million figure? Someone's done some calculations.
This is the internal figure that was put to the RDC when they were issuing the warning notice stage as to how much the FCA internally contemplated that the redress on the basis being mandated in the proposed first supervisory notice would amount to.
To how many clients? I mean, what are we talking about per client? Do we know?
I don't know the number of clients, but that's the overall estimate, including interest, which adds considerably to the bill.
Because this all took place quite a long time ago.
Did. But that is the internal estimate. Of course, it's not agreed, but it's on the. There is a degree of specificity as to what part of the performance fee one deducts and what part of the management fee one deducts. I mean, it's open to questions why the performance fee should be deducted at all if there is no case that the performance was inferior as a result. But there are all sorts of questions that could be raised. But I'm dealing with it of necessity at a very high level of generality. I must accept the discipline of a strikeout on the pleading. We do say that in a case where you're not saying loss of return and where we have challenged what is the loss, there is simply no answer. And it's not enough to say substandard service by reference to incommensurate. That doesn't get you beyond the standard category. Lord, that's the point. Well, can I then move on to the jurisdiction of the tribunal to hear a new case? The grounds of both parties engage, obviously, with this important question as to the jurisdiction for a new case. And I'll come back to what a new case means, of course. This is an issue which we say is substantially at large for this Court of Appeal, both as a matter of previous binding authority and indeed even more at large as a matter of the parties' stances, because you've been presented with 3 cases on behalf of the authority, the primary, secondary and tertiary case, and you've been presented by 2 cases by us, and indeed that doesn't exhaust the list of possible solutions, and Lord Justice Popplewell's waterfall gives some indication of a number of steps that may affect, could affect the outcome. You will have seen both parties' skeletons violently accusing the other of running new cases on the appeal, and that may be a matter of not the most significant question for this court, particularly where the matter is one of interpretation and the issue is at large. I have to say, in justice to my side of the court, we do regard the FCA's allegation as slightly the pot calling the kettle black. Our approach is new to a very limited extent. Our primary case, and to that extent we expressly reserved our position in the tribunal to argue this on appeal. it was effectively goes behind Jarbre, our primary case, as I'll explain, and we expressly, orally and in writing, reserved the right to argue it. It was not efficient to try and argue that in front of the tribunal. By contrast, the authority's self-declared primary case is entirely new, not even having been foreshadowed fully in the grounds of appeal. And we say it constitutes a radical break with all of the tribunal case law, and indeed with the position that the authority has taken in previous cases. Can I, first of all, come back to our case at a very high level of generality, just to dispel what seem to be quite profound misconceptions on the authority's part in the way it describes it in the skeleton argument, and before I come on to the detail, because in my submission it's important to have the battle lines clear before one descends to the detail. Our respondent's notice contains our primary case on the appeal. For your note, it's core 5, page 51 to 52. The matter referred to the tribunal is limited to the allegations contained in the decision notice, and so does not include other allegations which may have been ventilated during the authority's internal decision-making phase. For example, proposed in the warning notice and then abandoned, not included by the RDC, or even included in the warning notice and ventilated and then addressed but rejected expressly in the decision notice, which is the Jarbre position. We have not abandoned this case, nor realised that it is unsustainable, as my learned friend slightly optimistically suggests at paragraph 42 of their reply skeleton. We say that is the case which best fits the statutory language. That's where we would invite the court to reach as a result of construction of what the matter means. And it fits in best with the policy concerns that infuse FSMA. And that's the case we expressly reserve the right to argue in the Court of Appeal. It is not very different from our alternative case, which is effectively to accept Jarbre, and we say to accept the decision of the tribunal below in this case. My own friend sought to suggest that in some ways the decision of the tribunal in this case was at odds with Jarbre or different or radically different. We emphatically don't accept that, and I'll obviously go back to that case to explain that to you in due course. That case gives a slightly wider meaning to the allegations. It's not just the allegations in the decision notice, because it can include circumstances on which the decision notice allegations are based, so as to include allegations which were ventilated at the internal authority decision-making phase, proposed in the warning notice, possibly only where embodied, even if rejected in the decision notice. That is the area of difference between our primary and secondary case. It's quite a small difference, and it is actually a difference that makes no difference in this case to the outcome at all.
So is it fair to say that your secondary case just is the same as the primary but addresses the Jarbre situation? So in both cases, the entire focus is on the allegations, the breach of
Lady, yes.
Whatever it is.
Lady, yes.
In this case,
that is absolutely right. And in this case, because no one suggests that any of the matters disputed on which amendments are sought were indeed ventilated in the warning notice or in the decision or in any phase, or indeed in the decision notice, the difference between our primary and secondary case is a conceptual one, rather than one which has any impact on the facts or the court's decision in this case. And I advance it because I apprehend that conceptual purity in getting it right is an important matter for this court. And I'm therefore identifying those two cases and addressing the court on them with that caution in mind.
So just so I understand, if you have allegations in a warning notice and then you choose to make representations and you say we did X, but actually what we did was slightly different, and you then get a decision notice which says, no, we accept that what you did was slightly different, but that still is a breach and justifies the decision, and that's the basis for the decision notice, then that would be something that the tribunal could take into account because it's all in the decision notice.
Yes.
If, on the other hand, you choose perhaps tactically, to say we're not going to engage with the warning notice. We're going to hold our fire. You serve your decision notice, bound to be in the same terms. Then you can go to the tribunal and make this. And at that stage, the authority can't do what it could have done at the decision notice stage, and they've got to go back to basics and start again with a fresh warning notice, you say.
Lord, absolutely. That is our case, and it's absolutely the right case. The discipline is on the authority to get its case right at the warning notice stage, subject to any representations which are chosen to be made, and it is for them to put it in the right form. And if it's embodied in the decision notice, however it's embodied, whether following representations or without representations, that is the case. That is the matter which is being referred to the tribunal.
Does the authority, will the authority have had full disclosure by the warning notice stage?
Absolutely, absolutely. There's a long investigative process. The authority has extremely strong tools to investigate. The investigation may have taken years. There may have also been interchanges on draft warning notices, as there was in this case, draft annotated warning notices, 2 sets of it. There may be all sorts of prior stages. But I will take you to this because it's very important. There should be no suggestion that use of the expedited procedure, which the authority brought in a few years ago because they thought it was a good idea, to as it were, decide not to go to the RDC, in any sense creates a sense of sympathy for an authority left in the position that it's not, that as it were, has lost an opportunity to put its case right. And indeed, there is express guidance, which I'll come to in the decision-making manual, which says the authority mustn't and will not put out a warning notice case or invite the use of the expedited procedure, ask the person if they want to go to the tribunal, until they have effectively got full knowledge of their case. So that it's premised on that basis. And if I can anticipate even further, in this case, the BlueCrest recognised when it received the warning notice that there was absolutely no prospect of the matter being resolved in the RDC. There were fundamental issues of policy about the very power being exercised, which the RDC was effectively incapable of resolving because the RDC follows the FCA on matters of policy. So it was simply a pointless case as to whether or not to take it to the RDC stage, time and expense, and this was a case ripe for going straight to the tribunal. It is, in my experience, very rare for the expedited procedure to be used. Indeed, I suggest, and those behind me on the other side of the court will know better than I, but it was probably a handful of occasions. But this was absolutely a sensible case, and the court should make absolutely no assumption that the points that have led to the amended case, the wrong client issue, were even known to BlueCrest.
I mean, I'm addressing the question as a matter of principle, not by reference to what happened in this case.
But I understand. What you will appreciate that and to be unfair to my learned friend, he hasn't put a case on the facts. But you will understand, my lord, on my side of the court, there is some anxiety lest it be seen that this is all a tactical game by which the poor authority was ambushed and surprised.
I understand what you said.
That's not a case that's put against me, and it's emphatically not the basis on which the expedited procedure was used. Lord, quite separate from our primary and secondary case, which is not a different case, not a new case, but is part of their case, is at the recognition which we've referred to and developed in our skeleton, that it's necessary to pay very close attention when you're deciding what is the matter, what are the allegations, indeed, in the decision notice. Important to pay close attention to the nature of the power being exercised by the authority, to see what are the allegations that are being referred as the matter, and what it is that the tribunal is having to decide on referral. And that produces the conceptual distinction between forwards-looking and backward-looking cases, such as forward-looking, such as fitness cases, and backward-looking cases, such as disciplinary cases. I'll obviously need to come on to that in detail. I'm only identifying battle lines at this stage. But the point is that submission, which I'll come on to, is in the first place not in any sense new. It's relied on in a number of the decisions to explain why there is quite properly a greater ability to permit new points, if I can use points as a neutral term between allegations or arguments or whatever, new points to be advanced in fitness references compared to disciplinary references. It's an argument that was analysed below. The tribunal even characterised the fitness jurisdiction. Tribunal Judge Harrington referred to it as being, in a sense, an ambulatory jurisdiction, because the test which the tribunal, standing in the shoes of the authority, is looking at is whether or not the applicant is fit and proper. And because the allegation, therefore, is fit and proper, you have to be open to looking at evidence which postdates the date of the decision notice. Now, I'll come back to the detail of that and how it impacts, but the authority has gone wrong in taking this the fitness point we're making on these cases to be in some way a conceptual alternative to the focus on the decision notice, and in suggesting that we've, in a sense, changed horses in pointing out that argument. We haven't. It's part of the same two arguments, our primary case and our secondary case. The point is that in a fitness case, what is an allegation may look rather different to what is an allegation in a disciplinary case. And I'll need to come back to that and to the question of the difference, how clear the difference between the two sets of cases is, and where there are some powers that may look both ways, and how one deals with that, and how one deals with cases where both are alleged. All of those are working out of the principle, but at this stage, that is the principle. This is an issue which, as you have seen, has some considerable history in the tribunal. It's been grappled with in a series of decisions ever since Parker in 2004 and then Jarbra in 2006. And although the issue has, by a side wind, arisen fleetingly in the Court of Appeal, in the cases that Malone Friend has taken you to, it has never been, as it were, grappled with directly for decision. And I do know that this court's decision is awaited with a very great interest in a range of other cases. It's right that the court should be aware of the issue that comes to it. The issue, of course, is one of statutory construction. What do the relevant words in FSMA mean, the matter, in all sorts of contexts, running like a thread through the Act, the matter and the subject matter of the reference. But it also raises wider policy issues, we say, which must be taken to have been in the minds of the legislature. And importantly, they do arise in the context of in a specialist and perhaps slightly unusual context, which is far removed from ordinary civil litigation. In particular, the unusual relationship between the authority's internal decision-making process and the referral role of the tribunal on a disciplinary and a non-disciplinary reference. And the implications of the decision are relevant, of course, not only for the Financial Conduct Authority exercising a huge myriad of powers to which the words matter applies under the Act, but also for the Prudential Regulation Authority, the PRA, which is engaged in precisely the same terms. And they're certainly in DEP Annex A for warning notices and decision notices. There are a list of over 300 decisions in respect of which references may be made. Can I then, at the starting point, identify some of the competing interests which are engaged by the issue of what is within the scope of the matter?
Sorry, can I just, I may be getting myself confused, but we talk about the decision notice, and you referred a moment ago to referrals in non-disciplinary references. But we're concerned, aren't we, both with the scope of jurisdiction in relation to the supervisory notice and the decision notice in this case. Yeah. So when you use what's in the decision notice as a shorthand, we should read across. You say the same about the supervisory notice in
yes, I'm very grateful for that. That's absolutely correct. And I was wrongly, as it were, shortcutting as an example in saying decision notice. In general terms, the same considerations apply in relation to the first supervisory notice and the decision notice. And I'll try and identify where there are different considerations. But the issue of meaning of matter is very similar for the two, but there are added issues for the court to consider in relation to non-disciplinary references because of the different nature of the tribunal's exercise. And in short, we say our case is even stronger on non-disciplinary references Because there you see that the tribunal is doing something rather like JR plus, where the decision itself, the reasons in the decision, the allegations in the decision play a much larger role for the tribunal than they would in a case where it's effectively standing on a disciplinary reference, standing in the regulator's shoes and deciding what the regulator should do.
Yes, well, I don't want to take you out of your turn, but just so you know, speaking for myself, I'm not at the moment clear why you say that a supervisory notice which imposes a requirement in order to remain fit to practice is not a fit and proper question.
Yes.
Which, if you're right,
Yes.
that there is a divergence
Yes.
between the two different kinds of case. At the moment, I'll need persuading that we're not concerned with both.
Indeed, Lord. Well, I will emphatically say that it's not a fitness case. It is not, the proper characterisation is not that it's a forward-looking power about whether the person remains fit. Fitness isn't even mentioned. It's adding in a requirement to pay redress. That is the mechanistic exercise.
Requirement to what?
To pay redress.
Yes, a requirement as a condition of what? Continued authorisation to carry out regulated activities?
Well, no, it's simply a condition attached to permission.
Permission to do what?
To carry on regulated activities.
Yeah.
If there's no self-executing sanction following from that. If there was a breach of condition because the firm simply refused to cooperate, it would then be for the authority, of course, to decide on the next step, and one can imagine what that might be. But it's not right to characterise the first supervisory notice power is in any sense a fitness power. It's simply imposed, and we say that's the case particularly when you read 55L with, as we say you should do, 404 F7. But even if you were to be persuaded by my learned friend and to be looking at 55L on its own, even then, in this context, as made absolutely clear by the FCA's own guidance, this is a redress power focusing on what the firm has done in the past. Mm-hmm. It is something which the FCA clearly considers it has to do and varies permission to force it to do so. But it doesn't. It's not a fitness case in any way. I mean, one can imagine a case where the amount was tiny, for example, and the authority didn't think it had anything to do with fitness, but decided to do it that way. It's highly likely, my lord, I'll go this far, it's highly likely that if a firm doesn't comply with the requirement attached to its permission, that would be such a serious matter.
Well, you say it might have nothing to do with fitness, but
yes.
Was Mr. Burgess right to accept, I'm inclined to think he was, that the consumer protection objective that one's talking about is protection of future consumers by continued carrying out of business?
Well, you may have seen a number of notes going backwards. I don't accept that is a proper characterisation of what's being done. What is happening in a variation of permission is simply the imposition of a redress requirement. It says nothing about fitness, and it's certainly not protecting any future consumers at all. BlueCrest, in fact, is no longer even operating as a fund. I'm not sure if it even was at the time of the imposition of the first supervisory notice. Yes, BlueCrest continue to be fit and proper insofar as they're operating. There's no suggestion that they are not. There's no suggestion that they were not before they had redress required. There is the only connection with fitness and properness is purely contingent, in that if a firm doesn't comply with a requirement, it may be that the authority ends up concluding they're not fit and proper. Unless, of course, they've got good reason for it. They may have all sorts of excuses or reasons for not doing so.
So let's take restitution, for example, where there's an ability, subject to arguments we've had, but assume there's an ability either simply to order restitution as a form of redress or to impose it as a requirement. Now, the imposition of it simply in the form of redress, I'd really accept, has nothing to do with fitness and properness. It's, you've done this, you must make redress.
Good, yes.
But if it's imposed as a requirement, as a condition of continuing authorization to practice, does the authority not have to justify that by reference to the effect that doing it or not doing it might have in relation to your fitness to carry out future activities. It can do it, can it? Simply if it wants to.
Absolutely, and the proof of the pudding is that there is nothing in the supervisory notice or anywhere in the papers that analyse in any way BlueCrest's fitness.
No, never mind this particular case.
It's
Just take the general
Yes.
principle.
Yes.
The objective that is invoked under 1C for making it a requirement is that it's desirable for an appropriate degree of consumer protection.
Good, yes.
And you say, do you, that doesn't mean future consumers?
It doesn't mean future consumers. It
It
doesn't
means
impact-
it's
yes.
appropriate for us to do it so that you protect the previous consumers.
Precisely. And that is what is so startling about the use of the power.
And
In
why-
this
why-
case, it's the first time ever. That is precisely, it isn't.
Why, sorry, just forgive me, can I just finish the point?
Yes, yes, good.
Why would that make it appropriate to make it a requirement of permission as opposed to, in my example of restitution, simply ordering redress? You've got two quite separate
Yes,
powers, and
yes.
why would it be appropriate to use it to make it a condition of permission if, in circumstances in which one's hypothesising that there's no danger of any detriment to future consumers?
Laura's putting to me this category of restitution as a requirement on permission. I'm not entirely sure I'm following your logic. There is a restitution power which can be exercised. That can't be, as it were, folded in, or I found it very difficult to see conceptually how it could or would be, or why on earth it would be, as it were, folded in to a variation of permission.
Well,
variation of permission.
sorry, just forgive me. I thought you'd accepted earlier that, well, on the particular facts of this case, if what they'd wanted to do was to impose what they've done by way of exercise of 284 powers of restitution, then subject to the factual points, but on the assumptions we're making, they would have been entitled to.
Absolutely, and
to
that's
do
what
so.
one would have expected.
And then I think I put you, but I'll put you now. If they could do that under 284, could they not do it by way of attaching it as a requirement to permission? And I think your answer to that was no, because permission requirements can't be backward looking. Now,
Yes, absolutely.
you may or may not be right on that.
Yes.
Assume for a moment that I'm not persuaded by that,
Yes.
or we're not persuaded by that, so that it would be possible to do it in either of those two ways. They're not the same. They're two different things. One is pure redress, and one is connected with continued authorization to carry out regulated activities.
No, that last stage, I respectfully part company with your lordship at that point.
Yeah.
It's unconnected with the ability to continue. One has permission before the variation, one has permission afterwards, and nothing that the authority is deciding or the criteria which is taken into account are anything to do with fitness whatsoever. It could do it with a £10 debt if it wanted to, or it could do it with in an issue where there was a major problem, assuming it could do it at all. So assuming against me that one can use 55L alone, 45L as it was before 2010, to impose a redress requirement, it might be expressed into, I'm assuming for present purposes that a restitution requirement, a redress requirement is effectively something which can be brought within the notion of a requirement on past conduct. If it was imposed by that route, and that's precisely what we say they can't do unless they meet the four corners of the 404 F7, but if they could do it, it would still have absolutely nothing to do with fitness or be forward-looking. It would simply be 55, it's what they purport to have done. They don't purport to have said anything about BlueCrest's fitness at the time, before or after. All they have done is said, we have this very wide power to advance consumer redress. We are exercising it to advance consumers' interests because we think it's appropriate, and this means that you have to engage in this redress scheme. None of that says anything about BlueCrest's fitness or is connected with it in any way. There's nothing in the authority's reasoning, or could there be, where the authority would have to even decide this is necessary for BlueCrest to continue to be fit. And there's nothing in that decision-making process isn't gone through, and understandably it's not gone through. We say that the restitution power, like other toolkit powers in FSMA, were and are available to the authority on the terms on which they're set out. They are the familiar routes by which the regulated community expects the authority to be securing redress. And the authority has used the restitution power effectively in a number of recent cases, such as the Tesco misstatement case that I referred to yesterday. This case is a step into the dark. It is a new use of a quite separate power that many people didn't even ever think existed, except in the terms of Section 404 F7, where it has been where it is addressed in guidance in detail as to how that works, and that is the power which is exercised. And so this is a step into the dark power, something new and far more unconstrained than any of the other powers, be it restitution, be it 404 F7. All the obligations, whether all our 4 conditions are correctly derived or some of them, it is with one bound I am free. Here I have a power that all I need to do is decide that it's desirable in the interest of consumers, and suddenly I can do anything and impose unlimited liability. That's why this case is significant. But even that exorbitant power, as we say it is, which the authority is purporting to exercise, even that power is not constrained by any considerations of fitness and is not forward-looking. I'm just reminded there is, of course, a separate cancellation of permission power. If at any point in the future the authority decided the firm is not fit, it can exercise a cancellation of permission power. That's quite separate power. There's no question of it obviously being exercised. So, Lord and Lady, I was about to identify at a high level some of the competing interests which we say are engaged by the issue of what's within the scope of the matter in relation to the Upper Tribunal. First point is that this goes much further than circumstances in which the authority may be able to amend its case. It involves the question of what the authority can put in its case in the first instance in the tribunal. It happenstance that this issue has arisen on an amendment in this case, but when you're looking at it, one has to look at it from the perspective of what case can the authority plead. We say that there are 2 major respects in which, given the authority a wide discretion to advance a fresh case in the tribunal, would conflict with the policy aims and objectives of FSMA. The first is that the reference procedure is not like a court rehearing or appeal, nor is the overall process like civil litigation. It's of great importance that FSMA permits a reference to the tribunal by one party only, the subject, and that is done in order to ensure that the subject has an opportunity to have a fair and Human Rights Act compliant opportunity to challenge the administrative decision of the regulator. Parliament decided in 2000 and consistently in amendments since not to permit the authority the power to challenge the decisions of its own semi-independent RDC, likewise with the PRA. The authority is meant under the legislative scheme to be stuck with its own decision reached by this semi-independent body at the administrative stage. And that independence is from the Enforcement and Markets Division, who will have typically investigated the case all the way through, maybe over several years, have managed the case in front of the RDC, and if there's an oral hearing at the RDC, effectively acted as a party in the RDC effectively. It's an administrative tribunal, administrative body, but it hears representations from 2 sides. And indeed, that same body will be running the case in the tribunal. And it is, we say, of the first importance that the authority is not put in a position to be able to stifle that right, the subject's right to a rehearing or review, by threatening to run a different and more severe case in the tribunal if the applicant chooses to refer. There's an obvious inter rem chilling effect, risk, if the authority can say, if you have the temerity to refer the RDC's decision to the tribunal, we will bring a much worse conduct case against you that you were found guilty of, pretty colloquially, in the RDC proceedings, and consequent exposure to a much greater penalty. And that risk would subsist even if the authority's power to run a new case were controlled merely by discretion rather than by jurisdiction. The threat of a case may be enough to stop a person referring. the individual or firm is entitled not to be put to his election in a sense as to whether to risk further or greater charges if the matter goes to the tribunal. He or they do have to accept a risk that the tribunal may increase the penalty. That's increasing the action. That can clearly be done. And that has happened in individual cases. But what they should not be able to be exposed to, should not be required to be exposed to, we say, is the risk that a more severe, different case may be brought. It's also simply not the authority's function to challenge on a reference the decision of its own semi-independent decision maker, to be challenging its own decision if it disagrees with it. That's not their function. So why would the legislation give them a right to challenge that decision on the happenstance that the subject has chosen to refer it? The second fundamental reason for the importance of the referral procedure is that it provides a vital discipline in ensuring that statutory notice procedures at the administrative RDC stage are complied with. They are essential for guaranteeing the procedural fairness which the legislation requires. As you've already been shown, FSMA requires the authority to provide adequate reasons for its action at various stages. First, at the warning notice or first supervisory notice stage, to ensure the subject is properly informed of the case they have to meet, assist it in deciding whether to, and if they do, make effective representations. But also, beyond that, to assist in considering, addressing the question of what disclosure, delimiting disclosure, because the authority has to make disclosure dependent on what the allegations are in the reasons in the warning notice, to assist in the subject deciding whether to contest the warning notice or engage in settlement decisions at stage one. All of those reasons are reasons that the warning notice reasons are hugely important. And I should say in passing that I was slightly baffled by one submission which I thought was made, and I apologise if it wasn't made. The warning notice reasons are absolutely not set in stone. No one is contending that the authority is not permitted to change its case between the allegations in the warning notice and the allegations in the decision notice. So things come out in the RDC, arguments are made, point to point differently. It's a question that, a point that Lord Justice Popplewell put to me this morning, I think. I absolutely accept, fully accept, and there's nothing in the statute to suggest the contrary, that the RDC can say, well, okay, this needs adjustment, this needs changing, this alters the case, and the allegations can change, evidence can change, reason, anything can change at that stage, provided, of course, that the RDC no doubt has to give the individual a fair opportunity, or the firm a fair opportunity of responding to a changed case if it's made. That would no doubt seek to do so. But there's no matter constraint at that stage between the warning notice and the decision notice stage. There's no matter affecting.
Sorry, and in the supervisory notice equivalent,
Saying between the first and the second supervisory notice.
Although we haven't got to the second yet.
Yes. They operate slightly differently because you can refer the first supervisory notice direct to the tribunal, unlike the warning notice. In some ways, the first supervisory notice functions like a warning notice if you have a representation stage and go to the second supervisory stage, which is then the decision notice. But because you're given this right to go direct to the tribunal, it can also function effectively like a decision notice for other reasons, because you're then referring the first supervisory notice and that becomes the matter. So there it looks like a decision notice. So in terms of the way the concepts work, it has a slightly two different ways facing status.
Although it probably is equivalent if the expedited procedure is used, because the decision notice will then be the same as the warning notice.
Precisely. So in that case, now, and then one comes to the decision notice reasons, of course, separate, you've seen that again, I'm not going to take you back to them. The requirement for reasons in the decision notice, or the supervisory notice second stage, if that's reached, requires that the subject be informed of the reasons for the authority's adverse decision. And that's obviously important, first to understand its basis, and secondly, to be able to take an informed judgment as to whether to refer the matter to the tribunal. Now, the legislation does not provide any distinct sanction or enforcement mechanism to require that adequate reasons be given. There's nothing in the statute apart from saying the authority must give reasons. There's nothing, what happens if they don't? Judicial review is highly unlikely to be available, as we've seen, because there is, of course, an alternative remedy to the tribunal. The case then goes to the tribunal. And that is precisely where the whole job issue then becomes acutely important. Because if the authority can, as my learned friend's case, primary case will have it, simply decide at that stage what it wants to allege on any basis, new, old, on deploying anything it wants, then there is absolutely no way that the right to reasons at the warning notice or decision notice stage means anything at all. No enforcement mechanism, no way of enforcing. And what one sees is the tribunal on a number of occasions in the reasoning emphasizing the vital importance of a clear and effective definition of matter as operating as a incentivization on the authority to be careful not to fail, not to neglect, or not to choose not to set out its reasons properly at the internal administrative stage, and only later, under the more forensic focus of the tribunal, if the person chooses to refer, then develop new allegations to support the decision or to do a proper analysis. One can see that without any criticism at all of the authority, there is a huge temptation. You're preparing a case, 95% of cases settle. Very, very few cases go to the tribunal. I'm probably wrong, it's probably 99 point something, but even if one talks about large cases, very few cases go to the tribunal. So there is a totally understandable incentive on the authority to, as it were, get out warning notices and decision notices. Most cases will settle after a warning notice and the decision will be agreed. And the decision notice will then be an embodied and agreed notice. And there's a great and understandable incentive, therefore, which is precisely why this control is so important, to get out a case to see if the person will settle and tie things up. And if the authority is able to do that with the assurance that it can look at things more seriously and do a proper analysis of evidence and work out what its proper case is when it gets to the tribunal, in the rare case where it gets referred, then one encounters the real problem with the right to reasons at the warning notice stage and decision notice stage. And what one can see that reasoning, and in view of the time, I'm not going to take you to detail the cases on this, but can I, for the court's note, refer you to Peter Marku against the authority. It's in tab A7, tab 60, page 1679. And the tribunal there said the warning notice and decision notice provisions confer fundamentally important procedural protections for applicants, enabling them to know the case they must meet, make effective representations, understand the reasons for the decisions, and whether or not what basis to refer them. And they also make the point that this is paragraph 434, references a continuation of a regulatory process that has begun by way of the warning notice and enforcement proceedings before the RDC. In those proceedings, the applicant is entitled to know the full nature of the allegations, findings, and decisions made against him by the authority in order to consider whether to contest the regulatory action proposed or whether to make the reference to the tribunal.
Sorry, can you just give the page number again?
Apologies. Lady, it's the two paragraphs I read were paragraph 28, which is page 1679, and paragraph 434 at page 1757. And can I make two further points as to the importance of reasons at the internal stage? That stage, proceedings have been private. Very few cases go to the tribunal where proceedings are in public. There is a great need to ensure that proper articulation of decision notice and warning notice reasons at a stage where as I said, made the point already, the great majority of cases never go beyond that. They settle at the private stage. There's another independent reason, which is that there's a third-party rights regime embodied in section 393 of the Act, which is in tab 4 of the bundle. I don't think I need to go to it because my point is a general one. Third parties who are prejudicially affected by an allegation in the warning notice or the decision notice get third-party rights. If the warning notice makes an allegation against a third. So there's a case against a firm and there's an allegation against an individual that they have acted wrongly and they're identified. They get third-party rights and can turn up at the RDC stage if it's exercised, or can choose to exercise it even if the other party doesn't, and make representations to the RDC. And furthermore, they have a right, if the matter goes to a decision notice, to put in their own reference and for the case to go to the tribunal. Now, if there are not full and proper reasons at the internal stage, then those individuals may be disabled from exercising their rights at the private stage of be saying why their reputation shouldn't be affected by the criticisms made of them. And if the authority at the public tribunal stage can introduce new allegations potentially affecting those third parties, they then have to face them without having had the benefit of any third party rights at the private stage. There's another reason for the importance of the reasons, as well, of course, and I've mentioned disclosure as well. One final point before I get to the actual matter of construction, and it's an important one. The legislation itself has carefully accommodated the tension between, on the one hand, you need to accommodate with flexibility what may come out of the more judicialized tribunal procedure. Because, of course, in the tribunal, you've got witnesses, you've got cross-examination, you've got all these matters which don't exist at the warning notice, decision notice stage. So, of course, it's likely that with that more forensic examination, new matters are going to arise. But the legislation itself accommodates that. And can I ask the tribunal the court to go back to the provision, section 133 in tab 4 on page 98. I'm sure the court's aware of it, but it hasn't been addressed so far orally in these this hearing. That's the provision that says the tribunal may consider any evidence relating to the subject matter of the reference or appeal, whether or not it was available to the decision maker at the material time. And we say this is a really important provision, both for what it does say and for what it doesn't say. It permits the tribunal to consider fresh evidence, whether or not it's available to the RDC, and so the tribunal doesn't have to go through some sort of Ladden-Marshall exercise before deciding whether to admit fresh evidence. This, we say, accommodates the reality of the tribunal's process, turning up fresh evidence relating to the authority's case and the subject's defence. And it would no doubt be both undesirable and impractical for fresh evidence relating to the case which emerges in the tribunal advance not to be taken into account. But, and it's a big but, the provision is limited to evidence. It doesn't begin to suggest, in fact it suggests the opposite, that the authority is entitled to advance a new case, new allegations. That, which is the subject matter of the reference or appeal, is fixed before the tribunal stage by the authority's internal decision-making process, by the decision notice, the allegations contained in it, and then by the subject's decision to refer or appeal it. If Parliament had truly intended to permit the authority to run a new case, contrary to the important interests I've identified, then one would have expected it to make it clear here that the tribunal is entitled to consider any evidence or allegations relating to the subject matter of the reference, or some such formulation. But of course there isn't such a provision, no such indication, whether in section 133.4 or indeed elsewhere in FSMA. Of course, on the authority's case, it says, well, the matter is so broad, is interpreted so widely, so broadly, or indeed we would say left contentless, because there's actually no meaning left to it, that it permits the authority anyway to make whatever fresh allegations it chooses, unrestricted by its administrative process. But of course, if that were the case, quite apart from all the other objections which I'll advance to such a wide proposition, then section 133.4 would be unnecessary. Why would one have it? If the authority's case in the tribunal is untrammelled by requirements to advance the same case as in the RDC or in the decision notice, then of course the tribunal should consider fresh evidence. It would have to adjudicate on new allegations. wouldn't even need stating. The provision would be entirely OTOs. And so the distinction is between allegations, and allegations is not just a legal label. His allegations is the breach and the factual case which is pleaded to support the allegation. It's rather like the difference between facts and evidence. In you plead facts, you don't plead evidence. Anything that turns up in the tribunal by way of new evidence can be pressed in aid to support the case embodied in the decision notice. What can't be done is changing the allegations in the decision notice, and this provision reinforces that. And finally, on this, I would ask the.
Sorry, when you say the allegations is the breach alleged and the factual case pleaded, so are you saying that the statement of case basically has to track the decision notice?
Lady, yes.
With no substantive.
With those substantive changes. That's our primary case. And that's exactly what happens in most cases. One sees, indeed, in this very case, you see that the statement of case is rather a word processed version of the decision notice, turned into something which looks a little bit more like a pleading, although there's tribunal emphasis that it shouldn't be equated with a statement of case in civil litigation. But precisely, that in the ordinary course of things is precisely what happens. The tribunal was well aware of these competing policy tensions and the need to construe the legislation having regard to the strong policy interests in limiting the authority's total freedom of manoeuvre at the tribunal stage. I would remind this court that the tribunal chair, Judge Harrington, was an extremely experienced judge who presided over financial services references in the Upper Tribunal's Tax and Chancery Chamber for some 11 years. And indeed, before that, was the head of the authority's RDC for 7 years. So he'd, as it were, experienced both sides of the decision-making process, presiding over both sides. And to the extent that when you're reading the judgment, you're looking at some of these policy considerations which are adumbrated in it, we do ask the court to bear that in mind. There was no one, we respectfully suggest, better placed to appreciate the policy aspects and the implications of where the line as to what is the matter ought to be drawn. My lords, my lady, I was then going to go on to address the decision-making process under FSMA, but most of this I'm going to omit because it's in the skeleton. All my learned friend has addressed it. All my learned friends juniors have addressed it, and there's very little dispute as to the structure between the parties. The only points I would add, first of all, I've already made reference to the obligation on the authority to make disclosure at the warning notice and the decision notice stage. I'm not going to repeat myself, just for the court's reference. If I didn't give it, it's section 394, which is at the supplemental authorities, the first supplemental authority on our side at page 2. Provides the authority must allow the person access to the material on which it's relied in taking the decision which gives rise to the obligation to give notice, and any secondary material which might undermine it. And that determination by the authority, which is a difficult and onerous task in many cases, in a big case, of working out what material is in support and what material might undermine, is absolutely necessarily made by reference to the case as being brought first at the warning notice stage and then reconsidered at the decision notice stage if there are differences between the two. My lord, in relation to the nature of the RDC as a decision maker, I've already referred to the measure of independence. I won't address that further. I would simply refer to the court, if it wants to read a little more on that, the description of the RDC in the judgment of Mr. Justice Michael Green in a recent case, the authority against Carillion, and this is in Authorities Bundle 3, tab 6, Authorities Bundle 6, tab 57, page 1570, paragraphs 91 to 92 and 94. The first paragraphs are, in fact, the first two paragraphs of that are submissions by me acting on behalf of the authority. So they're with the instructions of the authority as to the RDC process. And the third one is the judge's finding, paragraph 94, that the RDC can't be described as an independent and impartial tribunal in Article 6 terms, which is why, because this is obviously, they will frequently be determining civil rights and obligations, which is obviously why you need the tribunal stage as an injection of Article 6 protection. Well, I've addressed the expedited procedure. Can I again simply give a reference to one passage of that, DEP 5.1.8F, which is at bundle A2, tab 18, page 391. This is simply making good the proposition that the expedited procedure can't be used to ambush the FCA by taking the matter to the tribunal in circumstances where the authority perhaps hasn't put its case properly in order, because there's in DEP is an express provision that the authority will not put out a case for use of the expedited procedure until it is satisfied that it's reached a stage where it properly understands the case and has properly put its case.
So is it up to the authority to make the expedited procedure available then?
It is up to it to decide when it is available.
Oh.
It is a right which the authority a few years ago decided to give. It didn't exist before in 2017 as part of the changes with the partly contested case procedures. There was a big changes in 2017. They introduced this right to skip to, as it were, leapfrog the RDC and go to the tribunal. So it's a right which I think is always offered. I'm not sure whether the authority can decide not to offer it. In fact, in respect to your ladyship's question, someone on the other side will know the answer to that. I shouldn't say yes to your ladyship because I'm not actually sure whether the authority can decide it's simply not an appropriate case to offer that. I'm not sure. But in any event, it's certainly in the authority's important point is it's in the authority's control as to when that is offered, that it has, as it were, fully investigated and understood the case and effectively set out its case. I'm instructed that. What is this? So I'm instructed that it does offer it once it's reached the right stage. The reference I'm giving is DEP 5.1.8F, supplemental bundle page 381. Once it has, as it were, promulgated the warning notice, it will then offer, the expedited procedure is then on offer. Can I then come on to the issue of construction, my lords, my lady? Now, the operative wording on which the tribunal, the jurisdiction of the tribunal depends in this case, appears in 3 sections. I don't need to go back to them because the court will be well familiar with the wording by now. It's section 55Z3(2) in respect of the penalty. It is section 200. Sorry, it is. In respect of the supervisory notice and the variation, it is section 208, the authority supplemental bundle 1 for the decision notice. And those two both give the right to require the matter to the tribunal. And also integrally involved is section 133, entitled Pleadings Before the Tribunal General Provisions, which contains further references to the matter in subsections 5 and 7. And as you've seen, the subject matter of the reference in subsection 4, to which I just took you. But of course, we as we've seen, there are a huge number of references to the matter in various parts of Bismarck. We say that the starting point is that the natural and ordinary meanings of the words, read in their statutory context, point clearly to an interpretation of the matter, which may be referred, as relating to the allegations as contained in the decision notice or supervisory notice. In the first place, the provisions conferring the right to refer appear in each case in close proximity to the provisions dealing with the relevant statutory notice. So, for example, in relation to section 208, is the FCA's first supplemental volume at tab 1, page 2.
Sorry, supplemental.
Yes, lady. There've actually been 2 supplemental bundles from the authority. I think it's the first,
Yes,
isn't it, the
I've got
longer
it.
one? Oh, I apologise. Apparently you only filed one. We've been handed 2, but you've only been blessed with 1. It is that bundle, tab 1 has section 208 in, which was omitted from the main run. So one sees the section is actually headed decision notice, and one has the trigger, the requirement without delay to give the authorised person concerned a decision notice, and then one has 2 subsections further, the referral power. If a regulator decides to, over the page, impose a penalty on the authorised person under section 206, the authorised person may refer the matter to the tribunal. So there is already an intimate link in terms of proximity in the sections, and also we would say in terms of the structure, in terms of the context between the decision notice and the matter. Now, may be asked, and it was asked, well, why doesn't it just say the decision notice rather than the matter if the matter is meant to be limited to the allegations in the decision notice? We said there are a number of clear reasons why that wouldn't have been done. The first point is that matter is used generically to refer to allegations contained in different statutory notices, not just decision notices, also includes supervisory notices. So when one comes to section 133, which is the general section dealing with proceedings before the tribunal, general provisions, one sees this is accommodating both references from decision notices and potentially supervisory notices. And so, for example, in subsection 4, the tribunal may consider any evidence relating to the subject matter of the reference, whether or not it was available to the decision maker at the reasonable time. You couldn't have something referring to the decision notice because it might also be a supervisory notice. So it made sense to use a generic term capable of accommodating different statutory notices. And similarly, in subsection 5, it can either determine or remit the matter to the decision maker. It's catering not just for references from decision notices. Perhaps a slightly more fundamental reason why it wouldn't have said decision notice is that wouldn't be strictly accurate. The role of the tribunal is not to sit in judgment on the decision notice as a document. Yeah, it is not to take over the decision notice and itself rewrite the decision notice. Its role, particularly evident on a disciplinary reference, I'll come separately to a non-disciplinary reference, is effectively to sit in the shoes of the authority and decide, in the words of 1335, what, if any, is the appropriate action for it, the decision maker, to take, the matter referred to it. And the FCA then takes the action. The FCA takes the action and promulgates the relevant notice, final notice or further decision notice. So that also explains why it would have been perhaps thought inappropriate to characterise the reference as passing to the tribunal the decision notice itself as a promulgated document, rather than the matter, which effectively, we say, refers to the allegations advanced by the authority in the decision notice. As a side note, I do say that the tribunal's status as a referral body looking in a disciplinary case into the matter de novo is in no way a consideration in favour of a wider interpretation of the matter, as my own friend sought to suggest. Its de novo status in such cases says nothing about the jurisdictional ambit of what the tribunal is entitled to look at de novo. Indeed, if anything, the de novo jurisdiction points the other way, because the function of the tribunal is looking for itself in some ways more like a first instance decision maker about what is the appropriate action to take. It makes it all the more important that the tramlines of its inquiry are clearly set out, because a de novo decision maker effectively may have a lot of internal scope as to which way to go, and the tramlines, we say, are clearly set out by the matter, by the allegations in the decision notice. can I, in this context, then come back to the position of non-disciplinary notices in subsection 133(6)? Because we say these provide a further indication that Parliament must have intended a narrow conception of matter. The distinction between disciplinary and non-disciplinary references was added by way of the 2012 Act. Before that, all references were treated as disciplinary and dealt with in the way in which disciplinary references are now treated. So when one sees the amended section 133 at page 99, one sees that the original regime is effectively subsection 5, which used to apply to everything, and then we get the new regime, the non-disciplinary regime, in subsection 6. And this is we've already looked at this in some detail. What is clear, we say, is that the jurisdiction is more akin to a judicial review style of review of the underlying decision, albeit with what we might call JR plus heightened scrutiny. And for these purposes, I don't need to mark back into the question of exactly how far that goes. There's clearly it's clearly plus in that one can determine issues of fact as well as on a greater basis of intervention than a judicial review court could. And it may also be, in answer to the leadership's question from earlier, that the matters to be or not to be taken into account may be influenced by that determination as to fact. Because obviously if you determine a fact, then that may have consequences that you ought to have taken that fact into account.
I'm not yet persuaded that the lease is exactly the same as a judicial review.
Well, Milady, I respectfully see the point, because if you're I think Mr. Burgess was absolutely right to compare that to relevant and irrelevant considerations. That's exactly what it looks like. But
it's
of
much
course,
more
relevant.
corrective, isn't it?
Well, yes, relevant or irrelevant considerations can be decided on different bases. In a typical judicial review case, if you want to say this should have been a relevant consideration, you either have to show it was a statutory condition, or you have to show that it would have been irrational for the decision maker not to take into account. In a heightened scrutiny case, you may be able to go a bit further than that, say even though it's not irrational, this was something which was clearly important that they got wrong, which should have been taken into account, and that might be enough in a heightened scrutiny case.
So where do you get heightened scrutiny?
Heightened scrutiny is one. Lord, the tribunal's findings are limited to findings as to issues of fact or law. Now, obviously, issues of law is familiar, but issues of fact. A judicial review court would not normally be making findings as to issues of fact.
Now, just heightened scrutiny in the public law realm generally, that isn't that, is it?
No, it's different.
It's quite different.
Well, Lord, there are a number of different heightened scrutiny jurisdictions. They can depend on, for example, whether it's Human Rights Act violation, which is involved.
That I understand.
Yes.
What is meant by heightened scrutiny, or anxious scrutiny, as it's sometimes put and so on, is not making findings of fact.
Well, it may give the judicial review, the administrative court, a greater ability, indeed, to decide whether the decision maker got issues of fact right or wrong. I mean, that's what one of the attributes of anxious scrutiny. It may not turn it into a primary decision maker on matters of fact, but it may give it a greater power to intervene. And I don't think this is a dispute between the two of us, because my own friend stood up and introduced this as a judicial review jurisdiction, and he's the one who used the judicial review plus description in the first place.
And I don't have any difficulty with it being judicial review plus.
Yes.
I'm just not entirely convinced myself that it's analogous to what is described in other areas of public law as heightened or anxious scrutiny.
No. Well,
it says what it says.
Yes.
It's plus. Certainly, I think agreed on both sides that deciding issues of fact or law is certainly plus to standard judicial review. I'm not sure, for my own part, that giving it the label heightened or anxious scrutiny is.
But it may not be helpful.
It's not helpful to me anyway.
Yeah. Well, and it may not be helpful. It may not. In a sense, this is not part of the building blocks of my argument, or nor I think my learned friends.
No.
It is. What we say is important. It is a form of review jurisdiction. Judicial review jurisdiction is going to be clearly seen. Which is modified.
Which is plus, anyway.
Which is modified. Yes. And that for my present argument, that is precisely the point I'm making. It is a form of judicial review determination. And classically, and in this case, decision review determination starts with the decision under challenge. You're not stepping into the shoes of the decision maker and thinking, what decision should they take? You're looking at the decision and seeing whether it has gone wrong on issues of fact or law, or matters that shouldn't have been taken into account, or on procedural reasons. And it does not make sense, we submit, for the matter to be given such a wide definition that effectively the decision evaporates. There is no decision or allegations on my learned friend's case. The authority can put in its statement of case whatever it wants to put. And it is simply incompatible with the concept of the tribunal on a non-disciplinary reference looking at the decision as pleaded in the statement of case and deciding whether it's gone right or wrong in the particular ways the statute defines. And when Parliament enacted the non-disciplinary route in 2012, it must therefore have been proceeding on the basis of a conception of matter which is substantially narrower than that which my learned friend put forward as the primary or secondary case. And indeed, we have an argument of statutory interpretation, which I'll come on to, by which we will argue that the authority must be taken to have endorsed the Jarbray approach in general terms, because by the time of the amendments, not just in 2012, but further amendments reenacting provisions of matter in 2018, right up to 2023, there is already a well-established body of case law in the tribunal from Jarbray onwards, setting out that at the very least, matter means nothing close to or approximate to a learned friend's case. And that, as a principle of statutory interpretation, is, we say, a reason why learned friend's interpretation cannot be right. I'm anticipating myself. I ought to come to the cases first. Now, Lords and Lady, we say that our primary case as to the interpretation of matter is also buttressed when one considers the ambit, as one should do, of the particular allegations being made in the decision notice.
So can I just go back to your previous submission? I'm not sure I understood it.
Well, yes.
It is that because these provisions were reenacted and still referred to the matter in the context of tribunal decisions as to what was meant by the matter, in particular Jarbray, it is to be inferred that the statutory intention was to adopt the interpretation of what was meant by the matter, which had been adopted by the tribunal. That's the submission.
It is, and it's bad of me to.
Nevertheless,
it's bad of me to refer to the submission without taking your lordship to any of the authorities. To which, if I may, rather than
no, I just want to understand the submission.
That's precisely the submission. That there's a Supreme Court, very recent.
But nevertheless, it doesn't mean
the Barras principle, my lord.
I'm quite familiar with the Barras principle.
Well, I apologise.
But what's puzzling me slightly is that it's nevertheless your submission that Jarbray is wrong.
Lord, yes, I'm well aware of that wrinkle, my lord. My submission is that our departure from Jarbray is a small fiddle at the edges. Jarbray, as a concept of focusing the matter on the decision notice, the allegations in the decision notice, is right, and as a broad principle, can be taken to have been endorsed by Parliament. It is starkly contrary to the sort of argument that says matter doesn't mean anything, you can do whatever you want. So the Barras principle battens on a fundamental difference of meaning. What Barras, I can't claim, would decide would be a matter which has clearly been nibbling at the edges in various of the tribunal decisions on, is it just the allegations in the decision notice? Does it go back a little way to what was ventilated at the RDC? Does it have to be embodied as a refusal in the decision notice? Is it enough if it was just dealt with, raised in the warning notice and dealt with? That small area, which is the minor area of difference between my primary and secondary case, I don't say is affected by the Barras principle. But where I say I can press it in because I can't say there's the Barras principle requires an authoritative, effectively authoritative judicial determination, which either means a highest court presumably, or a consistent line from a specialist tribunal can encompass.
What's the most recent Supreme Court guidance on the Barras principle?
About 2 weeks ago, my lord. Can I?
Do we have it, or
We do. You do have it.
What's it called?
It is called. Centrica Overseas Holdings Limited and Revenue and Customs Commission is
it's a-
16th of July. 16th of July. This year.
Supplemental authorities, the authorities, supplemental authorities.
There's two authorities on this point. There's the Centrica, and there's also a case of B and the Secretary of State for Work and Pensions, decision of Lord Justice Sedley in 2005. And I was intending to refer to both of those two.
Thank you.
But well, maybe I should, since I'm into the point, I'm maybe sensible for me to request at this stage, so you know where I'm going, and so you know what to look at when you're looking at the particular authorities. The starting point is the Centrica Holdings case decided just a few weeks ago. Can I take you? The relevant paragraph for our purposes is paragraph 52. This is tab. Sorry, I should say this is internal tab 7 of our supplemental authorities bundle. At page 170, the case starts, and at page 190 is the relevant passage. And this is a judgment of Lady Simler, with whom the rest of the Supreme Court agreed. One sees in paragraph 52, the case about the capital expenditure exclusion, introduced in 2004. And when it was introduced, the concept of expenditure of a capital nature was already well established in the tax code, had a long history, and had been subject to authoritative judicial interpretation in the case law. Turn to some of that case law below. The principle established in Barras and Aberdeen, and reaffirmed in R.N. Lewisham London Borough Council, applies, as Lord Hodge explained in paragraph 53, where Parliament reenacts a statutory provision which has been the subject of authoritative judicial interpretation. The Court will readily infer that Parliament intended the reenacted provision to bear the meaning that the case law had already established. So that is the principle, and the obvious question here is whether a series of tribunal decisions, and the series of tribunal decisions here in their terms, can amount to authoritative judicial interpretation or not.
And just give me the chronology of the reenactments that come in the various sections of section 133. Subsection 5 was how it was originally dealt with and applied to all references. I think you told us that disciplinary references.
It looks like the whole thing is substituted, according to footnote 5, FSA 2012, 1335 to 69.
Yes, because it's limited in the amendment to disciplinary references, and that. So it's 2012, is it, that you get? I think you said you get the distinction between disciplinary references and other.
Well, yes.
References.
So in 2000, the 2012 Act amended section 133 at that time. But even since then, there have been many later amendments to relevant operative provisions of FSMA, amending the definition of matter in other sections, which have occurred even since then. So in 2021, the Financial Services Act 2021 included, as you can see, looking at that same page, section 133(5)(a), where again Parliament refers to the matter. So that's only a few years ago. This is in relation to a reference under paragraph 7 of Schedule 6A, where the FSA has exercised a power under section 55 to vary or cancel an authorised person's four-way permission. So that's another example of matter being used in 2021. And then even more recently, in 2023, Parliament amended section 55Z3, which is at page 77, subsection 2A, to say that an authorised person who is aggrieved by the exercise by the FCA of a specific power under 55, the acronym, the numerals get worse and worse. Section 55NA, subsection 5, subsection B, may refer the matter to the tribunal. So that was in 2023. So if
Sorry, what is that? 55L.
55
Z-
amendment
sorry.
55Z3, subsection 2A.
Right.
So this is page 77. You can see a new 2A, which if one follows footnote 2 through, gets added by the Financial Services and Markets Act 2023. The matter is there again.
And you referred, I think, at one stage to 2018 as introducing something. Which was that?
Well, if I did, I
Perhaps I misheard.
think that. So simply on the question of what might amount to a authoritative judicial interpretation, can I just take you shortly to the other case in relation to the Barras principle in the bundle, which is B in the Secretary of State for Work and Pensions. That is also in the supplemental bundle back at tab 2. Starts at page 4. And this, as you've got to see from the head note, was a case concerning the meaning of failed to disclose in the Social Security Administration Act. And if one turns to page 35, sorry, paragraph 35, I apologise, which is on page 14, 13 to 14, one sees the Barras principle being engaged with. And on page 14 at the top, you can see Lord Justice Sedley noting that the claimant was entitled to rely on the repeated adoption of his construction by the specialist commissioners who daily interpret and apply this legislation. But as it happened in that case, the construction had not been sufficiently uniform for Lord Justice Sedley and the court to be able to place any weight on the interpretations. On the facts there, they declined to do so. But one sees there, back in 2005, and that was a case. That was a case where quite clearly the court contemplated that in principle, as a repeated construction by specialist commissioners, the tribunal falling into a similar category, could be sufficient for an authoritative judicial interpretation. So, my lords and my lady, when I come onto the authorities, I would ask the court to bear that principle in mind and to assess whether you're satisfied, as we say you should be, that there is a sufficient body of case law to place reliance on the principle. And so I'd made the point that one looks at the non-disciplinary reference procedures, it's very difficult to see how one could have a definition of matter that allowed the transmogrification of the decision, the allegations in the decision notice into something entirely new allegations in the statement of case, how that could operate with the jurisdiction which the court was authorising introducing by the 2012 Act. And then, my lords and my lady, I was going to address, I hope, shortly the category of case, which doesn't apply in this case, of course, the category of case in which one is effectively dealing with a forward-looking power. Would we say, as a matter of principle, one analyses the power under which relates to the decision which is being made, the requirements which were said to be being breached, to look at, so that one can elucidate what the allegations are in the particular case. Now, Section 206, to take an example, if I could start with obviously backwards-looking case, like Section 206, it's a backward-looking power in the sense that for its exercise, the authority has to conclude that the subject has, by its conduct or failures to act in the past, contravened a relevant requirement, for example, Principle 8. And we submit that in that context, the natural interpretation of the matter referred, in the context of a statutory notice embodying such a determination, is that it compromises the relevant requirement or requirements which the authority has concluded have been breached, and the factual basis as set out in the decision notice, on the basis of which the authority concludes that it's done so. So it's entirely of a piece, and indeed it follows what one looks to the statute to see what are the allegations embodied in the notice, and that confirms confirms the jurisdictional basis and confirms the matter. The situation is a little different, and this is not because I go to this not because it applies in this case, we say, but because there are a number of authorities applying this insight. The matter may be different where the relevant decision concerns a forward-looking power, for example, fitness or propriety of an authorised person, because in such a case, for example, if one considers a prohibition order under section 56, preventing the authorised person from performing regulated activities, that applies where it appears to the authority that an individual is not a fit and proper person. And on a reference to the tribunal, the matter is, as before, bounded by the allegations in the decision notice, which is what the matter means. It's not a change of, in any sense, a change of my case, but it's still looking at the decision notice. But what is the allegation may be different. In this context, having regard to the underlying exercise of the power being referred to the tribunal, the operative allegation may be simply that the person is, still present tense when it gets to the tribunal, not a fit and proper person. Can I show you one authority which encapsulates that reasoning, and it's been followed and approved more recently, and that's the case of Allen and Financial Conduct Authority, which is in tab 43 of the authorities bundle.
Sorry, did you say 43?
43, which is in volume 5 for those using volumes, starting at page 1092. In that case, the authority had sought to amend its case to rely on new allegations as to Mr. Allen's misconduct relating, it was a fitness case, and wanted to amend its case arising out of related proceedings, and they wanted to do that in support of its case that he was not a fit and proper person. And the objection was that these were new allegations which shouldn't be permitted as not being within the scope of the matter referred, consistently with the tribunal decisions in Parker and Jarbre. Those decisions were backward-looking decisions. Now, the Upper Tribunal in Allen considered the scope of Jarbre and Parker, but distinguished them while clearly approving their rationale. If I can ask you to turn to page 19 of the decision.
Paragraph 19.
Paragraph 19, I apologise. Page 1098. But as set out in another legal and general, FCA should usually be confined to the charges set out in the statement of case, but that may be not always the case where important new evidence unexpectedly comes to light or there are other special circumstances. In this case, I do not consider that the charge against Mr. Allen has changed. My view is that, as recognised by the tribunal in Parker, there is a distinction between an allegation or charge and the evidence relating to it. Pausing there, that's clearly right, because evidence is treated separately in the statute in subsection 133(4). I consider that the allegation in this case is that Mr. Allen is not fit and proper to perform any function in relation to regulated activities because he lacks honesty and integrity. It follows that the matter referred, or the subject matter of the reference in this case, is whether Mr. Allen is a fit and proper person. I regard the circumstances pleaded in the original and amended statement of case as evidence that relates to that allegation. The authority no longer relies on the evidence contained in the original statement of case for the reasons set out above. Effectively, some of the evidence it relied on was from a witness who'd been stigmatised as not telling the truth. The authority has not, however, withdrawn its allegation that Mr. Allen is not fit and proper. The authority now relies on other evidence, which it says shows that Mr. Allen is not a fit and proper person, but the allegation is the same. There was new evidence saying he'd lied in other proceedings. The factual situation in Parker was, in my view, different. In that case, the allegation was of market abuse relating to specific dealings in shares. Market abuse in relation to other shared transactions would be a new allegation involving separate misconduct, albeit of the same type. That's a backward-looking case, of course. In the case of Mr. Allen, the allegation is general rather than specific. The allegation is not that Mr. Allen was not fit and proper in relation to a specific transaction or transactions. As the tribunal held in Jarbre, it is the allegations made in the decision notice and the circumstances on which these are based that comprise the matter referred. Allegation in the decision notice was that Mr. Allen was not fit and proper person to perform any function because he lacks honesty and integrity. Any evidence that relates to Mr. Allen's honesty and integrity, whether or not it was available to the authority at the time of the decision notice, may be considered by the Upper Tribunal.
You have to draw your distinction in order to maintain your case, because this wasn't just new evidence. There's new allegations at a more granular level than the judge adopted as being the only allegation that matters is not a fit and proper person. It was that he'd forged things, said false things at a key meeting, etc., etc., etc. That's not just evidence.
The judge described it as evidence.
Completely different pleaded case, isn't it? I mean, you're still saying he's not fit and proper, but
But the conduct is entirely different.
They were adding in a new allegation of different conduct.
Yeah.
But they were describing that here all as evidence. The authority now relies on other evidence. You see the second line two up from the bottom of page
Well,
109.
that's because
Which it says.
the judge in this case categorised the only allegation that mattered
Precisely.
at a very high level.
Precisely.
But in terms of the way you've been framing your argument,
Yes.
you're talking about an allegation as something at a much more granular level.
I am, my Lord. That's absolutely right. And it may be that
And in a way that,
Yes.
that these would be treated as new allegations.
Well, there's one response is to say that Alan hasn't drawn the line quite right. That actually slightly more than just the headline allegation of not being fit and proper should be an allegation. But it may be that the better way of looking at it is that in fitness and properness cases, the court is analysing because it's an ambulatory jurisdiction where it has to look at whether he is fit and proper. They're looking at that as a headline matter. That's the tribunal's inquiry, and everything that relates to that is potentially evidence. Anything that comes out of the tribunal, any assessment as to his fitness is evidence. Not a case which arises for decision today, and there are some lines to be drawn in a forwards-looking case as to exactly where the distinction is between allegation, fact, and evidence.
But, I mean, this case is 2013.
Yes, Milady.
So going back to your Barris point, in 2012 for the primary amendments, you haven't got this case law. You've just got cases that this judge is having to distinguish to reach the decision that he does.
Although of course there have been amendments all the way through to 2023.
Well, yes,
So, and
amendments to other provisions, but the key provisions are in place since 2012.
Lady, we would say that it would be almost inconceivable that Parliament would have approved different meanings of matter structured exactly in relation to different powers apart, I suppose, possibly from a difference in fitness cases to non-fitness cases.
My point goes to whether it's really established set of case law.
Well, Lady, I have sought to, as it were, I obviously needed to address Alan. We've analysed it and on the basis of the reasoning, which is that it's consistent because once you realise that it's an ambulatory jurisdiction with an is, then the tribunal is able to have a much wider focus as to what the allegation is and what can come in. Now, it doesn't apply in this case, and it doesn't indeed technically even arise for this court's determination. And it could be said that this is a bit too generous in that there should be a bigger category. The allegation includes not only the headline not fit and proper, but also the headline allegations.
I'm sure you explained this, but I'm afraid I've not focused on it enough. Is Alan a forward-looking case or a backward-looking case?
Alan's a forward-looking case. Yes. Look,
Even though it's based on past.
Well, it's not only based on past misconduct. What they're saying is that obviously it may any fitness case is highly likely to be based on what the person's done in the past, but it is forward-looking in the sense that we are deciding whether they are now fit. Now, maybe I shouldn't say maybe I should say present-looking rather than forward-looking. Although I suppose one's looking at whether they will be fit proper in the future for the purposes of whether a prohibition order is needed. That's why I perhaps used the term forward-looking. But effectively, one is saying that one's not just looking at past conduct and deciding whether someone did or didn't do it, or should or shouldn't pay redress, which is the two categories here, penalties or redress, are simply looking on past conduct and whether they justify the imposition of the penalty or the payment of redress.
As I understand it, these are cases which look at present status, albeit that they use past conduct as a guide to present status.
They'll take that
And
into
you
account.
and you distinguish that from a case which purely looks at past misconduct,
Indeed.
past conduct.
Three short points in relation to that jurisdiction raised by my learned friend. One, we don't accept that it entirely undermines our policy case, those cases. In terms of a chilling effect, a person who wants to argue that they are fit knows that they have to establish to the tribunal that they are fit, that it's an ambulatory jurisdiction, and that is a matter which the tribunal is going to address on everything, including hearing them give evidence. Typically, it's not a comparable jurisdiction in those ways. It's entirely different from a past conduct case. Blanford also raises the point that the same case may have both. There are many, not unusual to have a case where there is an allegation of misconduct and a penalty proposed and a fitness reference. And that is right. And we say in such a case, so be it, that there may be a difference in what is permitted. There's no conceptual difficulty as to why the authority may not be permitted to change a disciplinary charge against a person, but it can adduce new evidence as to whether they are not fit, subject, of course, to the tribunal's discretion. And it's also true that some powers...
Although on your case, it's just a matter of happenstance which they choose to use and whether they use both. There's no... They don't have different criteria as to whether they're entitled to do one or the other.
A forward-looking and a backward-looking case, my lord? Or...
It impose redress for past conduct.
Well, they're fundamentally different things. I mean, the authority can choose to do one or the other, or indeed both, in the same case. But they are fundamentally, conceptually and in practical terms, very different to whether or not the conduct of the person in the past merits the imposition of a penalty or some other regulatory action, and the question of whether they are not fit and proper, such that they're a threat to the regulatory system in the future, such that a prohibition order, for example, ought to be imposed. I mean, they could both be done, but they are different theoretically and in terms, as we see, of the consequences of making those different allegations, we would say. There may be some powers, and 55L, as my learned friend points out, is an example where different aspects of them are backwards looking and forward looking. So my learned friend pointed out quite rightly that 2A enables the authority to exercise a power if it appears that a person is failing or likely to fail to satisfy threshold conditions. That clearly is forward looking, has a forward looking component. By contrast, subsection B has failed to carry on a regulated activity, we agree backward looking.
So I'm so sorry, which section are you on at the moment?
Going right back to 55L, and the submission which my learned friend made, that section, the very section in this case, can, in a sense, can look both ways. And we agree with that. It's always necessary to look at the relevant power or powers actually being exercised in the decision notice, applicable to the decision in question. It's clearly right that some aspects of section 55L to involve forward-looking powers and some backwards. And for what it's worth, we say in this case that it is quite clear that section 55L with section 404 F7, a redress power, is par excellence a backward-looking power. It's obvious you're not looking at the continuing conduct of a person when you're exercising a requirement to pay redress to their clients who they may have breached a requirement in relation to. It is a backwards-looking power. 404 F7 makes that absolutely clear. And even if one is determining this purely under section 55L, as Leonard Friend contends, it wouldn't be any different. Can I shortly, quickly before the short adjournment, because I'm conscious that I have a lot to get through in my small part of my allotted time, and I'm going to have to pick and choose. But there's one particularly important submission I need to make about the authorities' cases. Because what I haven't addressed is their reliance on same action to drive a very, very wide interpretation of well, a contentless interpretation, we would say, of what a matter is. One might say narrow, I suppose, rather than wide. We say that they in functional terms, they place all constraints on the ability to advance a new case. The only constraint is the warning notice must propose the same matter. The decision notice must propose the same matter, and they derive that, as you will recall, from the two sections, interlinked sections, which require that warning notice and decision notices, and then the action taken by the authority consequent on the tribunal's reference determination must be under the same part of
This is the same part.
This is the same part. I'm sorry, same part of it. I'm using the same action as a shorthand. It's the same part of FSMA. And what that does, of course, is in functional terms to leave the jurisdiction of the tribunal to entertain new cases of fact and law unlimited. In actual terms too, the only restriction is imposed by a completely different provision, the provision requiring action under the same part of FSMA. So matter, so far as we can see, is left contentless. We say there's no precedent for that construction cited. It's starkly contrary to all the tribunal authorities, including decisions made on the authority's own urging in the past. And it's not an argument which, so far as I'm aware, it has ever advanced since Jabray. We say that it's got no force. I won't labour the extreme consequences in terms of the width, because you've already heard me on that. But we also say, looking at the statutory wording, there's no warrant for the construction. The justification in ascribing no content to matter is to say, in some sense, well, there is a provision requiring action to be taken under the same part of FSMA. That is an express requirement. Therefore, there can't be anything else. It doesn't follow, because the two can sit alongside one another perfectly sensibly. There's separate content, we say, in the requirement for the action under the same part of FSMA, and content, a content to the definition of a matter restricting the jurisdiction of the authority of the tribunal to entertain a new case. The starting point is that action proposed is deliberately distinguished in FSMA from matter. And one sees that, for example, if I just take you back to page to section 387, the warning notice provision. One sees page 146 of tab 4. Warning notice must A, state the action which the regulator giving the notice proposes to take. So there's the action. And then C, must give reasons for the proposed decision. So there's a rigorous definition throughout as to the difference between the action and the matter. And over the page on the decision notices, one can see the same thing, although they're both in section B. The decision notice must give the reasons of the regulator for giving the notice for the decision to take the action to which the notice relates. One sees in subsection 3 the requirement for giving a further decision notice which relates to different action in respect of the same matter. Now, we say there's no warrant for assuming that because there's a change of action is permissible.
Sorry, where's that? Subsection 3?
Subsection 3, page 149, my lady.
Section 3 is 388.
388, subsection 3. I'd moved over the page to decision notices, looked at 1B, and then I drew attention to subsection 3, which is the same matter provision. If you have a further decision notice, different action, same matter.
That suggests that matter is a broader and looser concept than action, because you can have action A based on a particular matter, and then action B based on the same matter. Is that right?
I think I meant to refer to subsection 2. Subsection 3 is dealing with a specialised situation where they've already taken action, they've already promulgated a decision notice, and it's potentially giving the person a further decision notice. This may be after a decision of the tribunal, after a tribunal reference, a different action in respect of the same matter.
Well, that
Yes.
distinguishes between matter and action, but at
Yes.
the moment I'm not quite sure what the distinction is that you seek to draw.
Yes, so let me address that, my lord. We say that even with no permitted changes to allegations, even if we are right and effectively allegations are fixed in the decision notice, and that trammels the tribunal's jurisdiction, it's entirely understandable that Parliament contemplated that the action might need to change and wanted to impose limits on that change. An obvious example close to home is in this case, take the example of this case of the financial penalty being imposed on BlueCrest pursuant to section 206. The tribunal's jurisdiction, we say, is limited to the allegation of breach, principle 8, and the facts that are said to constitute that breach. In other words, the conflict of interest in providing the investment management services. The tribunal's task is to determine the appropriate action for the FCA to take, and to take in relation to those allegations and facts. We say that comes out of section 133(5). The decision notice imposes a financial penalty. That is action 206 under part 14 of FSMA. Now, if there wasn't the restriction in section 133(a)(1), the tribunal could decide that, for example, rather than a financial penalty on BlueCrest, the appropriate action that the authority should take would be to vary the permission so as to prevent it from carrying out future investment activity. But that is something that would be under a different part of FSMA, section 55 in 4A, and wouldn't be permitted. Parliament, if it's effectively said, there are some changes of action which are too radical to allow, so the tribunal couldn't direct that. But the tribunal could decide that the appropriate action for the authority to take would be different action under the same part of FSMA, section, part 14, as the action proposed in the decision notice. So, most obviously, it could change the size of the financial penalty, or it could decide on different action in the same part. It could decide to a public censure under section 205. And importantly, none of that regime controlling the action, allowing changes in the same part but not allowing it to go wider, none of that would imply that the authority was permitted to change the allegations from those in the decision notice. The two concepts are completely separate. And my learned friend says, aha, you can change the action to this extent, that's what governs the meaning of matter. It doesn't, they're completely separate concepts. The action regime created by Parliament operates intelligibly and effectively, even if the authority is not able to run a new case at the tribunal.
But what subsection 3 does seem to identify is that if you've got to the decision notice stage and you make a decision, that's your first original notice, and the FCA then wants to change it and make a further decision notice, it can do so by identifying different action, but only if it's in respect of the same matter, so that the concept of something arising out of the same matter arises before one reaches the tribunal stage. It's inherent in
We can do.
it can do.
That provision may actually be envisaging principally that it's been to the tribunal stage and there's a change directed. But it is possible that it could happen of the authority's own, I suppose, subject to it could happen of the authority's own motion.
But without going back to the warning notice stage, if it relates to the
Same action in respect of the same matter, and that's assuming that we say the allegations are fixed. It's the same matter. It's not changing. It's not changing anything other than the action. Actually, I may consider that provision a bit further over the short adjournment, because it's very dangerous looking at a provision like that out of context. I'm not entirely clear whether it is actually catering for the FCA to have a change of mind and withdraw a decision notice and put in a new one, or whether it is structured to accommodate the tribunal telling the FCA to do something different after a
It's not
Yes,
expressly linked to the tribunals.
No. Right, you can come back to that.
Can I come back to that?
Yes. 2 o'clock.
All rise, please.